আৰু না আৰু একদম আগলৈ যাম নাই একো হোৱা নাই এনেকুৱা কৰি দিয়ে পিছফালটো এনেকুৱা কৰি দিয়ে পিছফালটো উঠাই নাই পিছুৱাই দিয়া নাই সেইটো কেমেৰাটো পিছুৱাই দিয়া নাই পিছুৱাই দিয়া আৰু পিছুৱাই দিয়ে বাজিছে From a reading of the various case laws placed on record and relied upon by the parties, it emerges that since blacklisting is an action which has adverse civil consequences, the same cannot be issued unilaterally and has to be preceded by an opportunity to be given to the affected party. The only requirement is that the opportunity should be an effective one, wherein the party in question does not suffer any legal prejudice. The requirement of affording a personal hearing after issuing a show cause notice would entirely depend on the facts and circumstances of the case. As laid down by the Honorable Supreme Court in the landmark case of Evolution Equipments, what is sine qua non before imposing the penalty of blacklisting is a reasonable opportunity. In the instant case, however, it appears that a proper opportunity was given by issuing a so-called notice dated 11/8/2021, where a specific allegation was leveled. The said allegation was not denied in its entirety, and rather use of forged fake documents was admitted. In that view of the matter, the court is of the view that demanding for a further personal hearing would be an useless formality, an expression which was used by the Honorable Supreme Court in the case of Aligarh Muslim University, which we have quoted. There is another factor which has intrigued this court. The impugned order clearly states that the action has been taken against Messrs. Simcon Abhijanpik JV. Even the show cause notice was issued to the said entity. The reply to the said show cause notice dated 10/9/2021 was also given by the said entity. However, it is not the JV which is the petitioner in this case. The petitioner is Messrs. Abhijanpik Infratech Private Limited, which is an independent entity. Though a certain explanation has been given in paragraph 1, the same cannot do away with the legal requirement that the challenge has to be instituted by the affected party. In view of the aforesaid facts and circumstances, this court is of the considered opinion that the petitioner has failed to make out any case for interference by this court. Accordingly, the petition stands dismissed. Towards the end of his argument, senior counsel for the petitioner, however, has submitted that taking into consideration that the petitioner has a working relationship with the railways for a long period of time, the period of blacklisting can be reconsidered. Therefore, the submission has been considered. It is on record that the present petitioner has a history of having a working relationship with the railways from a long period of time, which is demonstrated by annexing a number of work orders. In that view of the matter, even presuming that the impugned order affects the petitioner being part of the JV, the petitioner is given liberty to file an application before the appropriate authority of the railways to reconsider the period of blacklisting and reduce the same from 5 years. It is further directed that in the event such liberty is availed and an application is submitted in terms of the said order within a period of 10 days from today, appropriate authority of the railways would consider the same and pass a speaking order which may be communicated to the petitioner. Such consideration may be made within a period of 1 month from the date of receipt of the representation. Writ petition in the above without interfering with the impugned order. With the above observation, the writ petition stands disposed of.
My village rules. Lordship, I would like to mention item number 6 and 7, Lordship, for adjournment. Because after filing this petition, some second development has been made, Lordship. So
What is your name?
K. Islam, Lordship.
Sri K. Islam, learned counsel for the. But is the 22 matter still for motion? Why?
Lordship, after filing this petition, subsequent development has been
understood.
made,
It was filed in the year 2022. It was filed in the year 2022. We are in April 2023. Even notice is yet to be issued. If you want, you can withdraw this petition. You cannot leave a petition like this at the stage of motion for 1 year. Will not allow this.
Only today, Lordship, may kindly allow after.
Giving an adjournment for 1 day, 2 days is not an issue. We can. But have you seen the matter of 2022? Still at the stage of motion.
That's true, Lordship.
If you file it, you have to- just to move. You cannot just file it and take time.
Only for the day, Lordship.
We'll have it on 19th.
Lordship. Deeply obliged.
K. Islam Learned Counsel for the petitioner submits that there is some development for which the matters are required to be adjourned. Full stop. The matters are of the year 2022, which is in the stage of motion. Full stop. Considering the same, comma, though matter is adjourned, comma, the same is directed to be listed again on 19th so for motion.
Deeply obliged.
6 and 7.
Lordship, I beg to mention item 31 for adjournment,
Hmm.
which applicant advocate consent and due to for filing affidavit need for 3 weeks.
31.
31
You're for whom?
respondent.
So I'm appealing for the petition.
You're with Mr. Medhi.
Yes,
Your name?
A. Ahmed.
Okay. On the prayer of the respondents, matter stands adjourned by 3 weeks to enable filing of affidavit in opposition. Item date 31.
May it please your lordship. Lordship, I beg to mention item number 26. Lordship, the engaged counsel is unable to appear before this court due to some personal difficulties. Lordship may be. Lordship may please.
But it was by order. Why do you get a matter by order?
Lordship,
Why do you get a matter listed by orders by filing a mention memo and adjourn it?
Lordship, Lordship, instruction.
See, have you seen the matter? Why is it listed?
Yes, yes.
Why?
So for admission and disposal,
No, by why is this been listed today? At whose instance?
for Lordship, the matter pertains to
On the of passport.
It has been listed today. Why? Not automatically.
yes,
You had given a mention memo.
yes, Lordship.
Then why are you adjourning?
Lordship, this is my instruction from the senior.
Who is your senior?
Lordship, Escal.
No, we'll deal quickly in this kind of situation.
Lordship, kindly allow, Lordship, kindly fix next week, Lordship.
Not a question of fixing. We get a matter listed at your instance.
Yes.
For one mention memo, the entire registry is working to get it listed.
Yes,
And you take an adjournment. What is this kind of thing?
apologies, Lordship.
We'll impose cost. For this kind of conduct, we'll impose cost. You express urgency, we accept your argument. Then you take adjournment when the matter is listed. Be careful next time onwards and generally to the bar also. If yes, somebody falls ill, then also we can consider, but not as a routine manner. A prayer for adjournment has been made on behalf of the petitioner. Full stop. The matter has been listed by way of a mention memo filed by the petitioner. Full stop. Getting the matter listed and thereafter seeking an adjournment is not considered appropriate and reasonable. Full stop. Let the matter be adjourned. Matter stands adjourned by 2 months. Yes, next.
May
May I plead the lordship, my lord, item number 11, it has become infructuous, my lord.
I Dowry Associates.
Yes, my lord.
Shri DP Bora, Learned Counsel for the petitioner, submits that by flux of time, the matter has become infructuous. Shri, as Barua, Learned State Counsel is present, para, petition is dismissed as infructuous.
Obligement.
May I please your lordship. I beg to mention item number 3. Password for the day, lordship. Chaudhary is unwell today.
It is submitted that Shri I. Chaudhary, Learned Counsel for the petitioner is not well. Let the matter be listed on.
What a petition.
We'll have it on 19th.
Lordship.
May I please, Lordship? I beg to mention item of 46, Lordship.
Hmm.
In this case, we are appealing for respondent 1, 3, and 4. Lordship, we need 4 weeks time for filing our affidavit. We have taken
40?
consent for the petition.
My lord, I'm for the petitioner, my lord.
46, Lordship.
Yes,
Interim is there, my lord.
okay. On the prayer of Shri K. Kolita Learned Standing Council, all matters stands adjourned by 3 weeks to enable filing of affidavit in opposition. Para, 3M Sarania, learned counsel for the petitioners, informs that there is an interim order. Full stop, para. Interim order accordingly stands extended till the next date of listing.
Lordship, another prayer in respect to item number 5, Lordship. This honorable court has provisionally allowed us to contest
Item number
5, Lordship. Allowed us to file, submit nomination, Lordship, for contesting the election of Silpuguri Samawaya Committee Limited. Lordship, we need to take instruction regarding the outcome of the said election, Lordship. We have
On the-
taken consent.
on the prayer of Sri K. Kolita matter stand adjourned by 2 weeks to enable the learned counsel to obtain instructions. Corporation
No,
department,
Lordship, we have taken
2 weeks.
cascade of the Lordship.
2 weeks बोलो नहीं क्या बोला 2 weeks
Lordship, I beg to mention item number 15 might become infractuous.
50
10, Lordship, sorry. The money has been paid, my lord, non-permanent context.
10 15 matter
15, my lord. Item number 15, 2018 matter.
Yes, yes. Item 15, Lordship, I'm sorry.
item 15 matter
Item 15.
not 10 is item
Item 15, Lordship.
15, my lord.
he was correct.
Amarjit
Lordship,
Rohan.
Lordship.
3 M Sarania learned counsel for the petitioner submits that by flux of time. No, your grievances have been redressed.
My
don't
lord,
say
paid,
it.
money has been paid, my lord,
that-
contextual bill, my lord.
So I'm sorry, learned counsel for the petitioner submits that during the pendency of this writ petition, comma, the grievance of the petitioner has been redressed. Also heard Sri and Upadhyay learned standing counsel, irrigation department and Sri finance, anybody? Finance department
He can appear for B going.
and Sri, your name? And Sri H. Burwa, learned counsel for the finance department are present. Full stop. Writ petition accordingly stands closed. Yes.
My lord.
All right, Lordship.
Lordship, I beg to item number 14 on behalf of AK Progressor
Item number
14.
14. Yes.
On behalf of AK Progressor, we are instruction from our client not to press the matter.
Your name?
Didas.
You are not on record. Okay.
Oh,
Sri D. Das, learned counsel, appearing on instructions of Sri A.K. Purkayastha, learned counsel for the petitioner submits that there is instruction not to press this writ petition. Full stop. Forest department, anybody? Sri A. Barwa, learned counsel for the forest department is present. Para. Writ petition accordingly stands closed as not pressed. Yes.
Wait, please, Your Lordship. I beg to mention item number 16. The
16.
matter infractions, my lord.
Sri M. Sekya, learned counsel for the petitioners, submits that by flux of time, the matter has become infructuous. Ardib, Sri Asbur, learned state counsel, as well as Sri Ardib, learned counsel for respondents 3 to 5 are present. Please inform him. Writ petition accordingly stands closed as infructuous.
Oblige, Your Lordship.
Lordship, item number 28 and 29, Lordship.
Hmm.
In this case, I am supposed to file affidavit, Lordship. Actually, this is my fault, Lordship. I will file it by 21, Lordship. On 21, can it be?
The other side informed.
Yes, inform, Lordship. Yes,
Uh,
colleague. Yes, sir.
Sri P. Sharma, understanding counsel, AFDC prays for and is granted 2 weeks time.
On 21st, I will, or 2 weeks time. On 21st, I will file it. On date may be given.
2 weeks time. 21st is a Saturday.
Oh, sorry.
Or not?
26th.
21st is Friday. Okay, 2 weeks time. You have 2 weeks time.
Lordship,
Lordship, and-
I'm appearing for the petitioner in interim order is
Okay.
the
क्या बोला? Prays for and is granted 2 weeks time to file the affidavit of opposition. Para. Interim order passed earlier to continue till the next date of listing.
Lordship,
28 and 29.
I have a, Lordship, another series of matter, Lordship, from 48 to Lordship, 69, Lordship. This
Which one?
48 to 69, Lordship. I'm on the other side, Lordship. This Dr. Ashok Saraf and Goel has, I've taken consent from them and MK Boran. Others is not, they are not coming, Lordship.
You're for whom?
I'm for Mineral Development Corporation, Lordship.
Okay.
In this case, Lordship, only 22 is there. 8 cases is not been tagged, Lordship. arising out of same communication.
There are 8 more cases.
8 more cases, Lordship.
You have on the, you would like to have it on the same day. You have the list of the 8 cases?
Same day, Lordship.
You have the list of 8 cases?
Yes, Lordship, I have the list.
Ah,
I'll give.
okay. Inform the other council also.
Okay.
Sri P. Sharma, standing council. Minor minerals,
Mineral
Mineral Development
Mineral
Corporation.
Development Corporation.
Assam Mineral Development Corporation submits that in this series of matters, comma, there are 8 more matters which have not been listed, full stop. He accordingly pays for a common listing on any other day,
Lordship.
full stop. Sri Sharma has also given a list of those 8 cases
Lordship.
which are to be required to be listed along with the cases listed today. Full stop, para. Okay, jayega, huh? Those being so and so, huh? Para. Register to list these cases along with the cases mentioned by Sri Sharma on immediately after the bifurcation. Yes.
My number?
40,
Lordship, 69,
47 or what? 48,
48, Lordship.
48. 69.
69, Lordship.
Okay.
May I please, your lordship? I have mention item number 17, lordship,
17.
17, lordship.
Yes.
PK Das is leading in this case, lordship. He is not well, lordship. So matter may come after vacation, lordship.
Okay. It is submitted that Sri B.K. Das, learned counsel for the petitioner, is unwell. Revenue, anybody? Yes. List after 2 weeks. 17.
Oblige, lordship. May I please,
Is there any interim order here? This one in Tengabari?
No,
May I please, your lordship? I beg to mention item number 30, 2 weeks time may be granted so that I can file an affidavit in opposition.
30.
Please, your lordship.
You have for PWD.
No, I am referring on behalf of DNAT.
Not for the PWD.
I am appealing for the petitioner.
Okay. On a prayer made on behalf of the respondent, matter stand adjourned by 2 weeks to enable filing of affidavit in opposition.
Obliged,
Yes.
lordship.
may I please, your lordship? I beg to mention for item number 25,
23,
25, lordship.
25.
Due to some personal difficulties, it cannot appear today.
Who-
On
who-
behalf of Jukimur
On behalf of?
J. Roy,
Okay, okay.
kindly adjourn.
Okay, we'll adjourn. It is submitted. That's
Lordship,
J. Roy,
kindly continue
learned-
Lordship, kindly continue the interim order.
it is submitted that's no, a prayer for adjournment has been made on behalf of Sri J. Roy, Learned Senior Counsel, who is recovering from illness. Full stop. PDCL, have you informed? Yes. Sri A. Borua, Learned Counsel is present for the APDCL. Para. Matter stand adjourned by 3 weeks. Para. Interim order to continue till the next day of listing.
Oblige.
May I please, your lordship? With the consent of the other side, I beg to mention item number 12. Lordship may kindly join this matter today for A. Sharma's in personal difficulty.
You are mentioning on behalf of Mr. A. Sharma.
A. Sharma, yes.
Okay, 18 matters. No more adjournment, huh? It's a matter of 2018.
Yes, I know.
Will not grant further adjournment. This time we are granting. A prayer for adjournment has been made on behalf of the petitioner. Full stop, considering
Perfect.
that the matter is of the year 2018, comma. The court has reluctantly acceded to the said request, directing listing of this matter immediately after the bifurcation. Item number ho gaya, yes, 112.
Lordship, I beg to pray for listing of matter tomorrow.
Listing is in court number 4, not here.
By explanation, item for 88 and 89 of the supplementary list.
88, 89.
Lordship, what has happened, Lordship, we have received the parawise comment, but we have to file a reply firstly. And secondly, senior counsel, Mr. A.K. Bhattacharya also not feeling well today. Lordship.
Okay.
Therefore,
You inform the other side?
Yes, Lordship, we have counsel for health is here, veterinary we have informed.
There is a private respondent also, Mr. Batra.
Yes, Lordship, we are calling him, but nobody is picking up the phone.
Inform him,
Yes.
when do you want?
Any day after 28.
On the prayer of Sri BP Bora, learned counsel for the petitioner. Matters stand adjourned by 2 weeks to enable filing of reply affidavit.
Okay.
Para, interim order passed earlier to continue in the days of listing.
Lordship, we need both the matters interim orders.
Yes, there's one order, written.
Deeply.
2 weeks, so we fix a date, there's an interim order.
Yes.
Let these matters be listed on. On 28/2/8.
Deeply.
28/4.
Deeply.
Okay,
Your Lordship, back to mention item number 10, Your Lordship.
10.
Your Lordship, I am paying a BF of Slim SP, right? Due to personal inconvenience cannot appear to your Lordship.
Then item of 2015.
We have to file an additional affidavit, Your Lordship. We'll file it after the just after vacation, Your Lordship. Kindly give time till then.
15 matter, not adjourning. Don't even think of. 9 years matter, 10 years matters, you know. Yes, next.
May I please, Your Lordship. Lordship, here the petitioner is in custody since last 603 days, Lordship. FIR, Lordship, is at page number 21, Lordship. 3 persons are
Mr.
named.
Sharma, which is this case?
My lord, here is
Support case.
Support.
my lord, suppose.
What was this case?
Lordship,
Which
here
one is
the
this?
3
It was
persons.
rejected by this court earlier.
Rejected, my lord.
Yes,
After rejection, they are second time filed, but they are withdrawn. Second time withdrawn. That is third time, my lord.
No, it doesn't matter, but no, remember, what was the incident?
Lordship,
What was the incident?
Lordship, may kindly come to page number 21, Lordship. Here, Lordship, 3 persons are named in the FIR, Lordship. From the possession of the petitioner, nothing has been recovered. May I read the FIR, Lordship?
Let us come to the first order passed by this court.
My lord.
Yes, Lordship.
Page 71, my lord.
70.
71.
71, Lordship.
71.
'72 would be relevant, Lordship. After perusal of the parties, 4th paragraph, Lordship. Lordship, may kindly come to page number 73, Lordship. This is the second time, Lordship, we move the bail petition, Lordship. This court is of the view that passing any order in an application for bail based on the depositions made by the witness on.
That we have read.
Yes, Lordship.
Now, what is your case?
Now, my case is, Lordship, that here, Lordship, at the time of submission of charge sheet, 8 numbers of witnesses were cited. Out of the 8 witnesses, Lordship, 7 has already been examined till the month of September 2022. From September 2022, the last witness, Lordship, he is not turning up, Lordship. Last 8 months, Lordship, Lordship may kindly come to page number. I have next order sheet, Lordship.
Who is that witness?
Witness is, Lordship, FSL expert, Lordship.
Yes, why don't you use an official witness?
Official witness,
Take
Lordship.
steps immediately. Get the trial,
Lordship may kindly come to page number 75.
75.
75.
FSL, yes.
29/2022. This is the order dated, Lordship. Summon the FSL expert. Thereafter, Lordship, 8 dates have gone by, Lordship. But he is not turning up. All the dates, Lordship, I have annexed all the order sheets, Lordship. Next, page number 78.
Mr. Sharma, this is not proper.
My lord, my lord.
And Lordship,
Not
out of
granting
the
bail has got nothing to do with an expeditious and speedy trial. That is his right. And this is an official witness,
My lord, officially.
not some witness who is absconded, whose whereabouts you could not trace out. He is an official witness, the government officer.
Lordship, out of the 7 witnesses, Lordship, all the, nobody has said anything about the petitioner, Lordship. Even, Lordship, I am not on that, Lordship. In the month of September, Lordship, someone was issued to the expert, FSL expert, Lordship. Until date, Lordship, he is not turning up. Lordship. It is 8
You took
months. Lordship.
instructions on this.
My lord.
Have you got the copies of the deposition?
Yes, Lordship, yes, all the, I have annexed
See,
all
we
the
have,
petitions, Lordship.
As a general rule, we have said that while considering a bail, we will not go by the
Scan copy,
substantial piece of evidence. That will hamper the
My lord.
case of either of the parties in the trial. He may be affected, he may be affected.
Right.
We are only on the jurisdiction of granting or not granting bail.
My lord.
We are not on the merits of the case. If we reject the bail based on the same materials, he'll suffer immense prejudice. Trial court will say that on this material bail has not been given. How can you give you the benefit? And if we grant the bail, they'll be in prejudice. So that generally we have said we are not going by. We will only go a prima facie view. But this, what you have now submitted, this is something relevant. We'll ask Mr. Sharma to have the instruction
My lord.
and also give a piece of advice that this is not done. From September till end of March, it's waiting for one witness.
Lordship, may call for report for registry, my lord, from the court below, my lord. Why there is delay for such 9
So
months?
that court, we'll call for the report. We'll
My
not-
lord, my lord,
But advice you can give as a PP,
my lord, my lord, my lord, my lord.
the court will issue summons. Court cannot enforce. It is for you, residency. Bring him, prove the case.
My lord.
At
Yes, Lordship.
Arts M. Ahmed, Senate Counsel for the petitioner, who has filed this application under section 439 of the CRPC in connection with so-and-so. First of- At the outset, the Senate Counsel for the petitioner has submitted that on 2 earlier occasions, the prayer for bail of the petitioner has been rejected by this court.
Once
Once
rejected,
Second, he further clarifies that in the second occasion, the bail petition was withdrawn as the trial had already begun. However, the Learned Council submits that out of 8 numbers of cited witness, 7 numbers have already been examined and the trial is pending since September 2022 for the appearance of the last, within bracket, 8th witness. Full stop. The records reveal that the witness is the FSL expert. Full stop. It is failed to be understood as to why the prosecution is taking so much of time to produce an official witness. Full stop. Para. List this case. And issue notice. List this case on issue notice. Then call for a report from on the status from the concerned court of so and so, huh? Which court?
special judge.
Special Judge Dhubri, correct?
Bilasipani?
Bilasipara, Lordship.
Bilasipara.
The Vilasipara, there is a special judge.
Yes, Lordship.
Special Vilasipara in case number
Special case number 34/2021.
34/2 यहाँ से देख लीजिए registry to obtain the said report. Registry to requisition the said report from the Senate court below. List on when 8
My lord.
Whether
scan copy is required or
No, till now. not.
My lord.
Can copy will only have the depositions.
My lord.
He has already given.
Otherwise, Lordship, I am not praising on the merit of the case also, Lordship, as because Lordship, all the witnesses has nothing said against.
Maybe after this order, they may also expedite.
My lord. Obvious. Highly obliged.
May I plead the lordship? Lordship, in this matter, the petitioners are the possessors of various exonia land situated at Satgaon, Palita Lambari. Lordship, they are in those lands since 1992, Lordship. And they are the regular taxpayers and they have valid electricity connection as well as the
Taxpayers, what kind of tax?
municipality tax, Lordship.
Municipality tax?
Yes, Lordship.
What about the land revenue?
Mm. No, Lordship.
Municipality
actually
pay
the-
taxes only for the property, not for the land. We are concerned with the land, isn't it?
Yes, Lord. They have the holding numbers also, Lordship.
Holding is given by the municipality.
Yes, Lordship.
What is your right over the plot land in question? What kind of right do you possess? How has the land devolved upon you? Is there any flow of title?
Lordship, they have purchased from,
What have you purchased? Title or the right to possession?
they have purchased by executing deeds, Lordship. By executing deeds, they have.
Deeds, what has flown to you? That is the question. Has the title come to you? Where are the deeds?
Lordship will get the deeds in page annexer 1, Lordship.
What is the deed?
Deed of sale, Lordship.
Sale
Annexer
of
1.
what? Possessory right,
Possessory right.
not the ownership right. What has been handed over? Only the possession, the possessory right. It's not ownership. You have to have some right.
But Lordship, Lordship, what happened in this case is that some ones tried to evict them forcefully, Lordship. And no government notice had been served to them. And when they approached the officer in charge of the Satgaon, they refused to take any action against those bones, Lordship.
Yes. Are you trying for an eviction process? That's a different matter.
No, this is nothing
What did-
relating to the eviction. It was
No,
something
you-
forcefully trying to dispossess the petitioner's land. Yes.
Then,
So their contention is, basic contention is that some goons and illegal elements, they're trying to forcefully drive him out of the, accordingly, FIR has been lodged. But FIR hasn't been lodged by any of the member of the petitioners society or any of the,
who has lost the FIR?
it's been lodged by some other person. I have got the detailed report. And after that FIR, there are two FIRs. First FIR is with regard to the illegal encroachment which has been mooted by some of the goons. And thereafter, another FIR has been filed by another person. That person's name is the Dr. Samsul Alam. He says that some persons have tried to forcefully enter the house and try to grab over their property. So this is another FIR.
Mhm.
And with regard to that FIR, investigation is on, and there is no lapses on the part of the police authority.
What is the status?
The status is the investigation is in the final round, in fact, so far my instruction goes. So that is her only contention that police haven't been taking any action after that. And police have been trying to be in hand in gloves with the accused. In fact, the accused have already approached the court, and this honorable court have asked them to surrender. Finally, they are in bail.
Who?
Accused person in the FIR.
Okay, the action has been taken as per the FIR.
Yes,
Madam, the redress has been,
it has been already
the
redressed.
grievance has has been redressed, substantially
It has
redressed.
been redressed, yes.
If the persons who are causing disturbance, they have been arrested. Action has been taken in your approach to the police, in your FIR.
It's a
What more do you need?
2021 matter. In fact, I think by now, the charge sheet might have been filed. I don't-
Your instructions,
Because the instruction dates back to 2021.
you get the latest instructions, we'll close the matter.
Yes.
Okay. Your name, madam?
Our Lordship on behalf of Aeropic.
R Saikia.
Lordship, on behalf of IRA.
It doesn't matter. Heard MSRR Saikia, learned counsel for the petitioners who submits that the writ petition pertains to the inaction of the police authorities to take action against certain antisocial elements who had tried to cause disturbance to the petitioner and to the extent of evicting from their respective plots of land which they are possessing in the Andgaon area,
Sadgaon, Lord.
Hadgaon area of Guwahati, full stop. Para. Riyaz Barua, learned State Council, however, submits that as per the instructions, action was taken on the FIR lodged and certain persons were also arrested. However, considering that the instructions is of the year 2022, the 21, the matter is adjourned to be listed on 8th of May to enable the State Council to obtain the latest position and status of the case, including the police cases, based on which this court would consider passing of appropriate orders in this case.
Obliged, Lord.
Next. Item 4,
Lordship, my senior's health is not well. Kindly pass over.
is not well. Who is just in here?
Yes, more.
HMO. Okay. Yes, ma'am. So what is this?
Lordship, regarding the issuance of PRC, Lordship,
PRC.
as per the last, as per the order dated 21/10/23,
Hmm.
Lordship, we have already produced the instructions, Lordship. Nothing survive in this matter, Lordship. Means the grievances of the petitioner have already been redressed.
A prayer for adjournment has been made on behalf of the petitioner. Full stop. However, Sri R.M. Das, learned standing counsel, NCHAC, submits that there is hardly any live cause of action to be adjudicated. Full stop para. Be that as it may, matter stand adjourned to be listed on 8th of May. Yes, instructions. PWD. Public Works. The Borough. Public Works. Yes. After a while.
My lord, we have responded this rejection order that was as per the direction to reconsider, my lord. But here, my lord, I have next, my lord, certain documents, my lord. By clear that in spite of the, my lord, eviction of process is carried out and the all eviction has been, drive has been completed. These persons, my lord, the certain who are involved in rearing the cows and buffaloes are still allowing. And the next one is the last page and
Can you find the affidavit?
yesterday we have filed it. It is flag A, my lord.
In which case you have filed?
It is my lord 1537. Second.
Ten for yes.
Well, look, this is a very limited prayer, my lord. They now this see the lordship will peruse the page 101 and my lord 103, 102. This is almost my lord, all vegetable series I am showing, my lord. This is almost my lord measured and it is only for 2 and 3 days that will be my lord. Keep in that stage. Otherwise, that will be all rotten, my lord. So my humble prayer is all this. My lord, I am showing the 2%.
What are these crops? Chili?
Not chili, then other vegetables, the brinjals and the garlics and all that there.
No, no,
Only-
you have already given a
Now, this is
photograph.
my lord, the measured, my lord, this chili, this is already my lord ripened. That is why I am showing, my lord. This is the high time for harvesting. This other person, my lord, with the understanding of the forest department, they are allowed to, my lord, harvest. I am selling these things, my lord. This is photographs, my lord, I am showing, my lord. Let me complete. You can submit. These photographs I am submitting, my lord. Whatever prayer is this, my lord, this is not, my lord, my lord, it is out of the question, my lord. This is, my lord, the lordship has a right to, at least it is one maximum time, my lord, 1.5 months. It is required for complete harvesting. And if there, my lord, other persons are allowed to continue with their activity within the, my lord, forest area, this is wildlife protection area. And
No,
so
we will not allow activities by anybody,
that this
but
is
we are only considering whether you can be given the scope to
I am
extract,
not, I am not
to
paying for-
extract the fruit of your.
only, my lord, to that extent. I am
Yes,
not
yes, what
doing
you say.
anything, my lord, more than. I give the undertaking, my lord. Only to harvest. This is no.
Not to
nothing-
harvest, only
Only
to,
harvest, my lord.
no, not to harvest. We will not allow you to harvest.
My
We
lord,
can consider only to extract the fruit of your labor, the whatever vegetables are there, you can just take it back. The only
this,
that,
this is only, my lord. This
that's
is
not
only,
harvesting,
this is only to collect the
collect
vegetables.
it.
And the garlics are, that will be another 1 month required for
Now
extract, my lord.
that will be far-fetched.
My lord, my
That will
lord,
far-fetched.
my lord, once, my lord,
It's been declared as a wildlife.
my lord, one thing, my lord, also we have to consider, my lord. Please, my lord, bear with me. Whatever action they had taken, my lord, this is on 25/1 first date, my lord, on which they have issued the notice. And the picking order by which, my lord, rejection all my claims. That is as per the section 18(1), they have issued the notice. That is on back on 2021. And after raising the objection and, my lord, claims, that was, my lord, rejected finally on 3/2. That is, my lord, after the issuing of the notice, that is before that the rejection, they have issued the notice. And if finally, my lord, the land come to their, my lord, purview under section 26A, that is on 14/2. So 14/2 from that onwards, my lord, they have all right. I am not claiming anything. But whatever activities are going on, till then period, my lord, that land not belongs to that forest department. That is under the revenue department, my lord. So with the consent of the revenue department and that too, my lord, honorable court order passed in 2006, we are cultivating, my lord. It is no objection was from any side, my lord. So where the, my lord, heaven would fall if, my lord, we are allowed to collect at least our right, my lord. It is part of the domestic product also, GDP. If we allow the hectares of land, vegetables to be destroyed, it will ultimately loss of the GDP, my lord. At least it is, my lord, sympathetically that to be considered. This is a last
We
resort
will
of
not
this.
go to the magnitude of GDP. We are only concerning your rights.
I am, my lord, one of
You
the,
don't
my lord,
need to worry
my
about the GDP of the
no,
country.
GDP countries, but every product of the, my lord, it is in
You
the-
argue on your case.
No, this is not my case, but this is part of the GDP, my lord.
Are you arguing
because-
on seriously arguing on GDP? Then I'll put questions
No,
on GDP.
No.
We
am
know
only
something about
one
GDP
line
also.
of argument, my lord. This is my humble submission because, my lord, crores of vegetables are
If
there.
you want to open up a deliberation on GDP, we can.
No, my lord, it is, I am not that, but consideration that to be considered by the lordship, my lord.
Yes, what do you say?
First,
No, on, we are only impressed with the photograph. I do not know what your reaction would be. See the photograph 100 and 101?
Well, I have checked those with authorities. My lord, in forest area, my lord, there is no such activity going on. Apart from that, my lord, taken. My lord, the question I put to myself, my lord, is he asking a negative equality, my lord?
Negative equality, we are not
My lord.
we are not
Otherwise-
impressed.
Otherwise, my lord, we also assail his, my lord, ground of.
See, 101 this doesn't look like forest area also, Mr.
This was not forest area, my lord. This is a nearby my lord, the bank of the river. And
No,
now,
this photograph,
yes, my lord.
where is the forest? You
This
have
is
said
not
this-
forest, my lord. They now, yes, my lord. That is I am coming to Lord Rossi, my lord. The
This is
activity,
not forest.
activity.
Then
was
how
not-
can it be an area of the area concerning the dispute
Yes,
in
my lord. That
question?
is, I am, from the very beginning, I am submitting
Is it
that.
from the, is this photograph relevant? Is it of the same
Yes,
area?
my lord. Now this area comes under their area, my lord. This is the question, my lord. Because earlier that is a bank of the river of Brahmaputra and one small, my lord, island. Where the all.
You don't see a
activity-
single tree here.
Yes, my lord. I have, in earlier occasion, I have shown, my lord, photographs, my lord, they have destroyed all the trees, my
My
lord.
lord, last weekend.
Even they cut the, my battle nut trees and mango trees and all other trees, my
No,
lord.
here, there is no question of cutting any trees.
No, no,
Come
here,
to
not, my lord. Earlier, I-
101.
No, no, my lord. I
This-
have,
This
No.
cannot grow within one day. These chilies are at least of 2 months.
no, no, it is, my lord, we have carried out the activity since long. This is the, my lord, totally, it is a, my lord, vacant land lying along the. my
Are
lord,
these
the-
cultivation in the same area that we
Yes,
are?
my lord, same area. Well, I have earlier annexed the all photographs belongs to our, my lord, community activity, my lord.
How can this be a part of forest area? There is not a single tree.
My lord, if it is not safe, my lord, can order for a drone photographs, my lord. Drone will say everything, my lord.
He's very standing in this court, my lord, as an organization, my lord. That affidavit
Drone-
taken, my lord, as a, my lord, his organization registered, my lord. He has not, my lord, first he is satisfied, my lord. That prima facie, my lord, he has a locus, my lord. Because he is, society is not registered, my lord.
That point will come later. We are exercising a jurisdiction at times.
That area is
We
showcasing.
may leave the veil, we can see for the person who are before us.
My lord,
On the merits, you argue on the merits.
that photograph, my lord, last week I personally visited. There's a very good area out there. My lord. This is the, my lord, transit area between,
Mohanta will say he has also
My lord,
personally
Urang.
visited.
That's Urang.
He
The area
comes,
between-
huh?
Yes, sir. Area between Urang and Kaziranga, it is a transit bit for the animals, man. And the area is trying to showcase, man, that area is covered with sandbars. Normally of them, because that is the way, that is the reason encroachment was removed, my lord. They have removed all the trees, they have cultivated trees. It will take time, my lord. If we take afforestation measures, it will take time.
Now, what about his limited prayer to allow the petitioners to extract the whatever vegetables, fruits of the cultivation?
That, my lord, has been taken care of by the Supreme Court of myself. If the wheel taking the same grounds, my lord. You have invoked this by effect. My lord.
And this prayer, if you do not consider now, considering after 2 months will not serve any purpose.
No
When
problem.
the rains will start, everything will be gone. You file your response. We'll decide on after a week.
Nothing will remain, my lord, after that, my lord.
Again, it's my lord. What right he has, my lord?
I am
No,
not
no,
claiming
no.
any right, my lord.
Well, it doesn't-
We are only giving you the chance because in the by way of this additional affidavit, something else has been prayed for. We want to have your views on record
Fine.
because see this photographs does not appear to be that of a forest.
It is originally.
Taking
that
the
was-
larger interest into consideration, but we fix a date. We fix a date. Today is 11th. We'll have it on 26th or 25th.
My lord.
Not on the 3 days before. Now, Bihu holidays will be until 13th till 18th. You can have it on 21st also, if you can file it. Depends on you.
21st, my lord, I can.
Well, I have some. In 20.
By that,
Then 25th is a Tuesday.
25th.
25th.
by this time, 50% that will well go.
Let us see. P. Mohanta, Learned Counsel for the petitioner submits that an additional affidavit has been filed on 10/4/2023. Full stop. In the said affidavit, the petitioners have highlighted the issue that rye vegetables are there, which the petitioners may be allowed to extract. Full stop. The petitioners have also tried to make out a case of discrimination, as certain other persons have been allowed to continue in possession along with their livestock. Correct?
Yes,
Their livestock, full stop. So, full stop. The aforesaid contentions, however, has been disputed by Sri T. Gogoi Learned Counsel for the Forest Department, who also prays for some time to file a response to the additional affidavit as new facts have been stated, full stop, para, in the interest of justice. At the same time, comma, the prayer of the petitioner is required to be considered expeditiously, full stop, in the interest of justice, that this matter be listed on 25th, Tuesday, 25th, till Tuesday. Full stop. In the meantime, the Forest Department may file the necessary affidavit and affidavit which may be placed on record.
Mass obligation.
Yes,
There are 6 petitioners before your lordship. 6 petitioners, we have come against an eviction notice.
eviction.
Yes, my lord, petitioner number 1. He applied before the authority. Before the authority, there is a LAC meeting which was held, and ultimately he paid the premium and patta was issued in his favor. At page 24, my lord. Page 24.
Okay.
Firas Miadi Jamandi, patta was issued in the name of petitioner number 1. He
What is
was-
his name?
Is 12, serial number 12, kindly see, my lord. Serial number 12.
Mazun.
Yes. This is petition number 1. Your lordship can note down.
Yes, yes.
Kindly see, my lord, the patta number is 712 on the top. 712. And on the serial number 2, that is on the extreme left hand side, number 2 is the patta number, which is 46. Lordship,
Tag number is 712.
is
not
712.
That was the
712 is the
dark.
dark number, and the patta is 46, new. On the extreme side.
Pata. Yes, yes.
Extreme. Now, this is the Assamese version at page 25.
Hmm.
Kindly say print date is 16/11/2016. Same,
Yes.
and it is reflected as the serial number 12.
Mhm. No problem.
Yes. Now kindly turn. Now all electronics. So I ask my client get the latest one. At page 23 is 26 the latest one. Latest.
Hmm.
So your lordship will kindly see at 12. This is founded in 2023. That 27 is the Assamese version,
Yes.
which you find at 28.
Hmm.
Find at 28, serial number 12. And the receipt which he is paying at page 29. Khazna receipt. Latest 14/12/2022. Name is Mohammad Mazun Ali. Lordship got it, my. At page
Well-
29.
Hmm.
29. Original page is 30.
Yes.
30. So this is over so far as petitioner number 1 is concerned.
Hmm.
Now we go to petition number 2, my lord. Petition number 2. This is the Land Advisory Committee which was held in 2005. Lordship, kindly note down the date. Now Lordship goes, kindly see at page 32. Minutes of meeting. And Lordship will see at page 33. Last paragraph.
Hmm.
The committee further decided that though this proposal are being passed by LAC, all such cases be hereby examined by committee headed by so and so. The other members of the committee shall be settlement officer, senior settlement officer, so and so, and so and so. The committee shall go into detail of the individual case, obtain all relevant information, include photographs of the house, if required, thereafter put out the proposal of DC after following all government instruction guideline issued time to time in this regard. Now at page 34,
Hmm.
this is 606 on the top.
Hmm.
This your lordship will kindly note down this petition number 5.
Tamnur
Yes, petition number 5.
is R5,
Yes.
P5.
Yes, petition number 5 in 606.
Yes.
And 607 is petition number 4.
Habibur.
Yes. Habibur now, his husband died, so automatically is in his wife. We have annexed that also. Habibur, 607. 608 is petition number 2. 1 kata 10 less. You cannot get more than 1 kata as per land policy.
Fakhruddin,
Yes,
T2.
yes. Petition number 2. Now kindly see at page 35 is the original.
This is-
35 is the original,
No
which I
problem.
read just now.
No problem,
36
no problem.
No, just I have shown because it's important, original also. Now we go further into 38. All this which is type,
Hmm.
38 is the original 606 down below. 606,
Hmm.
607 and 608.
Yes.
Lordship got it?
Yes.
Now we go to page 39, which is the regarding value of the land of Fakhruddin.
Hmm.
Petition number 2. So the government said this will be the value of the land. Lordship got. Premium will be fixed, my lord, on this one. Now this is SMEs at page 40. This is so far a petition number 2 is concerned. They have not fixed the premium, but they decided to make a settlement. So we go with petition number 3 at page 41.
Hmm.
Is the Azad Ali. All his documents starts from page 41 to 60.
Azad Ali's petition number
Petition number 3.
P3.
Yes, your lordship can note down his documents, all annexes page 41 to 60.
Okay.
Right, my lord. Now, kindly see at page 42 is the original, same. Now we go to 43,
Hmm.
whereby, my lord, as per the Land Policy Act, you have to state
Hmm.
Deputy Commissioner writes to the settlement officer saying that whether he possesses any other land. So there is a report which is given at page 45. 2007 report has been given of Azad Ali, petition number 3, my lord.
Hmm.
And they said that kindly see 1 kata so and so is not known where the person so and so. Any approach now, report will kindly see at page 47. 47. With reference, I would like to inform report submitted by so and so in the name of any family members of so and so under dispute, exclusive in the area falls under jurisdiction of so, send for information for necessary action. Now that necessary action, your lordship will find at 49. 49. Now they said, my lord, settlement officer write to deputy commissioner. With reference, I would like to inform on the basis of report submitted by record staff. After making spot verify, no patta land has been found against the name of following person, any of the family members. Kindly see number 3. Number 3 is the Azad. And this is the list of settlement holders, applicant 52.
Now you have been sort of evicted
Yes, now very interesting.
from Patta
All this,
land. From Patta land.
this part, petition number 1 is Patta land.
That's not Pata.
1 second.
Hmm.
The petition number 1 is the Patta land, 712.
Hmm.
Others, my lord, from 2002 they are residing.
Hmm.
All the process completed.
Hmm.
Only the premium has to be paid. And there is a report which they said settlement propose and decide to settle in the land. But the only different premium which they said these are the premium, they have not asked for any notice that you have to pay the premium. Now, my lord, now the dispute how it arose, kindly see at page 94. I am agreed by this. Well, absolutely no problem, my lord. I am petition number 1, there is absolutely no problem. They say now in the by purchase of the impugn notice, there is an underground pipe of Oil India. This is a problem. Now there is a report which is given in 2015 by the settlement officer, by the revenue department, and there is a dispute of revenue department and between Oil India. The revenue department says, we inspected in DAG number 713, there is a report, and DAG number 7, we don't find it. Oil India said, no, there is a detector which we said, 2015, cadastral map has also been changed. Now the position is that, my lord, they have to come and furnish a report before the court. And if really they want, then so for a petition number 1, an acquisition notice has to be given. If that's a Oil India pipeline,
Correct.
so that procedure has to be followed. Petition number 2 to 6, my lord, some type of right they have accrued because the government has decided, but premium has not been paid. My prayer at this stage, my lord, let them furnish a report. Revenue Department and the All India will submit a report. If it is really a All India pipeline is going underground, my situation will be different.
Kulja?
They have to give a
Any
report.
instructions?
First, in here,
Acquired?
government expert. According to oil on 20,096.
Including the land of the petition number 1.
Lordship, that time the tag number was 15251 and.
No, dark numbers may change.
571.
That is it.
Petitioner's number one.
No, even assuming the land of the petition, the dark numbers can change from time to time. At the time of resettlement, dark numbers.
Instruction tag number 713 and 8. So the petitioner one tag number was not in.
One is outside the
I
purview.
don't understand. If it is 64.
If one is outside the purview, why is the notice also
My-
served
I
upon
don't-
one?
This is one. May my learned friend is, I don't know, my learned friend may write 64. So what made the government 64 and today 2005, all the process completed? And kindly see the report. There is a tussle between the
Yes,
state
no,
government revenue.
just trying to extract something from him.
Lordship, there's a breakdown.
No,
And there is
no,
a
Kulta,
60
there are
that
two,
now-
that,
now-
Kulta, there are two issues. It may be a fact that the land was acquired. No, listen to us. Now, you have said that so far as the land number of petition number 1 is concerned, that is outside the purview of the acquisition process. Doesn't appear. That's 712.
Tag number 713.
No, on a private facie basis. You have got instructions, we understand. But it appears that the land of the petition number 1 is outside the purview of the acquisition process. Now, the notice, if you come to page 94, it has been issued to 7 persons. And number 1 is the petition number 1. So this is something very relevant. If the notice was not given to petition number 1, we would have understood that it is for them. But then also we may have to examine, because in the meantime, they have been given some right, some expectation. And even only the question of payment of premium, it is at that stage. But still then you can acquire. We're not against, but this is not an acquisition proceeding. Just simply ask them to vacate the land.
That's
In
the-
respect of oil, Lordship, verification pro pipe locator shows the pipe position under the end. And there safety issue. Because a accident happened, Lordship.
No, the-
There will be a-
Only,
Issue of public interest will definitely take into
my lord, only
consideration.
one, I will.
But
couple-
suppose we hold against the petitioners, but what is the remedy you are giving them? Are you giving them alternative plots of land? This is not acquisition process. Yes, Mr.
My lord,
Goswami.
by-
Third, we need us, senior counsel, for the petitioners. First of, the petitioners, who are six in numbers, are aggrieved by a notice dated 4/3/2023, issued by the circle officer, Guwahati Revenue Circle, by which the petitioners have been informed that lands under their position are encroached lands, and therefore they have been directed to vacate the same by removing all the structures, including materials, houses, etc., within 15 days. Full stop. It is the case of the petitioners that so far as the petitioner number 1 is concerned, the land under his position is a KP Patta land, over which the petitioner number 1 has been paying the khazna. Full stop. So far as the petitioner, the rest of the petitioners are concerned, though the land is our concern, comma, the process of conversion of the land is at the final stage.
Yes.
And only the premium has a premium are required to be paid. Full stop. Under those circumstances, comma, issuing the impugned notice is absolutely unreasonable and arbitrary, which would cause legal injury to the petitioner. Petitioners, what's the para? Issue notice returnable on 10th of May, not 10th of May, but a bit earlier. 28th of April. Can you bring the instructions?
28. 28.
28. Total 6 in numbers, 5 in numbers. Petitioners, 6 in numbers, huh? 5 petitioners. Madam, MS G. Hazarika Learned Standing Council Revenue accepts notice on behalf of responsibles 1 and 2. Whereas Sri N. Goswami and State Council accepts notice on behalf of responsibles 3 and 4. Sri K. Kolita and Standing Council Oil India Limited accepts notice on behalf of respondent number 5. Let extra copies be served on 5. Let extra copies be served upon the learned council for the respondents by tomorrow. Third, the learned council on the interim prayer. Full stop. While Sri Das, the learned senior counsel for the petitioners, has submitted that the impugned notice is expressly unreasonable, comma. Sri Kodita, the learned counsel for the oil, submits that the land in question was acquired for the Oil India Limited in the year 1960. 62 for laying down of pipelines. Full stop. He, however, clarifies that PFSI, the land of the petition number 1 does not appear to be within the area which was acquired for the oil. We are only saying PFSI, you may para. Be that as it may, by balancing the equities, balancing the it is directed that no adverse action be taken against the petitioners as per the notice dated 4/3/2023 till the returnable date. Since this order has been passed at the motion stage without proper instructions, the respondents would be at liberty to come up for modification, vacation, alteration of the interim order if so advised. It's up to you. Issuing of notice means you take whatever you want to get the instruction, you place it on record, we'll consider. Public Works.
I have a these pertains to
You need not elaborate.
I had a
Tomorrow the submission may be this, but it's to myself.
pilot, I had a chair with him yesterday only.
Or the name of the petitioner changed to Ardhar. It might happen.
We have talked about it yesterday.
What is it?
Pilot, yes, the admitted value that a sum of 37,500 they are supposed to pay the petitioner on receipt of the fund, last line, will pay. So my lord will direct authorities
On receipt of the fund. Fund is not there.
Too many bridges being constructed, Lordship. Scarcity of fund.
Until the time for 4 months. Keep this on record, ballot.
Part 3 M does. Council for the petitioner. Also heard Sri Ardhar, Standing Council. Public Works Department. Considering the nature of the grievance and the instructions received and the written instructions received by the Land Standing Council, this repetition is taken up for disposal at the admission stage. Full stop. Para. The petitioner is a practicing advocate who was engaged by the Public Works Department within bracket building to appear in an arbitration matter. Full stop. The petitioner had accordingly submitted the bills of professional fee after completion of the proceedings, which however has not been paid. So the bills amount to rupees 2,37,500. Full stop. Accordingly, this writ petition has been filed. Full stop. The Learned Counsel for the petitioner, Sri Das has submitted that there is no dispute regarding the services rendered by the petitioner as a counsel for a department in the concerned arbitration proceeding. Full stop. There is also no dispute with regard to the amount in question, and therefore non-payment of the same is absolutely unreasonable, which would require interference by this court. Full stop. Para. Sri Ardhar, Standing Counsel for the department, submits that written instructions have been received from the department as per which the entitlement per se has not been denied, and the reason cited is only lack of funds. Full stop. The written instructions which have been placed on record also indicates that on receipt of the funds, the payment would be released to the petitioner. Full stop. Para. After considering the aforesaid facts and circumstances and also the instructions, also the written instructions which has been placed on record as forwarded, while forwarding the letter dated 16/2/2023, this writ petition is disposed of by directing the respondent authorities to consider the case of the petitioner and take steps for release of the amount claimed in this petition towards professional fee as a counsel appearing for the department in the arbitration proceedings within don't say within, expeditiously and preferably within an outer limit of 2 months.
2 months.
3 months from the day from the date of receipt of a certified copy of this order. Full stop. Para. Petition accordingly stands disposed of. Full stop. Para. A copy of the written instructions forwarded by letter dated 16/2/2023 is made part of the records. Photocopy it. We'll retain a photocopy. Photocopy করে দেবো। Mr. Das? Fee in cash or kind?
Lordship, I would prefer the kind part.
But ensure that and involve the other members of the bar also.
May it please your lordship.
Yes. Which
Lordship,
one, Mr. Sharma?
yes, the petitioners
Which one? Which item?
79 years.
Yes, what is this?
Your lordship, the petitioners 1 and 2 are the husband and wife. Way back in 2014, they had bought a land from the landowners at that period of time. For that purpose, they have also obtained the sale permission for the DC
Where?
in Kamrup. Metro.
Which place? Ilako?
In the Moza is Beltola and the village is Bormuteria. That is Jayanagar.
Not Ilako area.
No, no.
Then what has happened?
Your lordship, the DC has accordingly at page 43 has given the no objection for the transfer of land by sale deed. Accordingly, the sale deed was entered into at page 44, your lordship. Page 44 and then,
Registered.
yes, registered, your lordship. Then the mutation order was also passed at page 53, reflecting the name of the petitioners. At page 53 down below, your lordship. Therefore, being satisfied with the case, land measuring so and so, bearing dark number 1069 and patta number 505 in Dispur Revenue, village Bormita, district of Kamrup, by virtue of purchase from Pattada so and so, son of so and so, the mutation in the name of Sri Pankaj Kumar Bhagwati, who is a petition number 1, son of so and so, and Srimati Malavika Bhagwati, wife.
Yes, Mr. You're for PNB.
I am only.
You're IDBI or PNB?
I am, yes, I am PNB.
PNB doesn't have any issue.
We have actually given this land in mortgage to
To
PNB
PNB.
and thereafter we had got the
No,
loan.
no, why IDBI is,
As far as we are concerned, their account is standard account. It took events regarding. It's really for the IDBI to comment.
no, but definitely there was a due diligence.
Yeah.
Before the sale had occurred and before you had taken up a mortgage. Now, where is the question of encumbrance as claimed by IDBI?
Your lordship, may I just one, page 62, your lordship, the no encumbrance has been also issued.
No, that we have seen.
Yeah.
No, how is the IDBI connected?
This land,
Yes,
your lordship, at page 40,
40.
the sellers, that is the wife and the son. Initially, the land was bought by Indra Kumar. Page 40, your lordship.
Yes. Now, you had purchased from Indra Kumar, isn't
We
it?
have purchased from the legal heirs of Indra Kumar.
It doesn't matter.
Yes. So Indra Kumar is the legal owner, and the schedule is at your lordship, page 41.
Yes.
And this dark number 88 and patta number 29 has subsequently been renumbered as 1069 and 505.
No, no, where is the document, any document which links this plot of land with any transaction with the IDBI?
Yes, your lordship, that's why we are now applying, we are going to the registry and we'll obtain all the information from IDBI, but now your lordship, the urgency is. The
And
police are-
that will take care of, but
Yes.
in the petition, were you able
I
to?
have given a averment, your lordship.
Not government. Government, we know, yeah, that's your case.
Yes,
Could you get hold of any document, either issued by the IDBI or any
IDBI, your lordship, page-
contemporaneous documents to show the action which has been proposed against you?
yes, your lordship, page 65,
65.
65.
Yes.
Here, your lordship, please find enclosed here a copy of the letter from, this is a letter from the DCP admin to DCP East. Please find enclosed here copy of letter number so and so received from IDBI Limited, house number so and so, possession properties in loan amount 1 katha 5 lesser covered by KP patta number 29 and dark number 88. So they are coming against this land and this is the land where my land is there. So they are now disturbing me. And anytime I may be evicted by the police.
This dark number and Patta number is yours.
Yours, mine. And
But
this,
under that Dagan Patta, are there any other lands?
no. But they are, I have also separated, I have applied for separation of my patta.
Is it a separate Patta or is it a common Patta?
Separate patta. The mutation order was there. Pursuant to that, I have applied for separation of my patta.
What is your area?
It's 1 kata 5 lesser, which is also equivalent to 3.28 R. Because of the urgency we are before your lordship, and we are in the process of obtaining information from IDBI and also the SITA from the DC office. It is taking time a lot.
Owned by Jitu Prasad. You're Jitu Prasad Goswami.
No, I'm not.
Of Mrs. Dispur. Now what is this? Unison Infrastructure.
Yes.
You are not Unison.
I'm petitioner one is Pankaj Bhagawati and petitioner two is wife Malavika Bhagawati.
There is some mistake, I think. Mr. Goswami, if you come to the impugned order at page 65, come to the written portion. The IDBI Bank Limited, so and so address, possession of properties mortgaged in loan amount of Messrs. Unison Infrastructure Private Limited, owned by Jitu Prasad Goswami.
Referring to a very old order of 27/10/2015, the then district magistrate means that these proceedings were here. There is no relation between which it appears that Goswami. There may be a case of either mistaken identity something.
No, you come to the schedule of in page 66.
The schedule is same, but the owner is shown as G.
This was the line I have bought from then at page 40.
The land records by FSI do not indicate. They will have to come in.
Or Sri R. Sharma. Direct conflict for the petitioner, who is aggrieved by a notice and by the action of the district administration in with regard to the plot of land which, according to the petitioner, was duly purchased by a registered sale deed. Full stop. It is the case of the petitioners, who are husband and wife, that who are spouses, that a plot of land measuring 1 kata 5 letter equivalent to 3.28 R ARE was purchased by them on a registered sale deed number 14044/2014 dated 24/12/2014 from the vendor who had a valid title for due consideration. Full stop. Thereafter, we'll have your name recorded. Thereafter, the name of the petitioners were mutated on the strength of the registered sale deed. Full stop. The petitioners have admitted that in connection with a housing loan, the land has been mortgaged to the Punjab National Bank, Jew Road branch, and the loan account has been regularly maintained without any complaint from the bank. Full stop. However, the petitioners were served with a notice dated 13/2/2020.
Should be 23.
What is this kind of notice? Oh, Mr. Goswami, advise your clients. This is not the format you write a date 2022-23. This is some kind of financial year. Did they notice at page 65? Or if it is there said while writing by hand, it should be struck off. Page 65, see the date. 13/2/2022-23. And nowhere it has been indicated. Even when signing, he doesn't write the year. Resume dates 23, huh? Okay. Issued by the Deputy Commissioner of Police within bracket administrative admin, Guwahati. That is the docket, not the issuing date. At the top, it is docketed. It was received on that date. Which issued by, served with a notice now, served with a copy of the notice, a copy of the communication issued by so and so to the Deputy Commissioner of Police, East Guwahati.
Your lordship, pursuant to page 68.
Requesting for action for eviction to be carried out from the plot of land which is identical to the land, to the description of the land owned and possessed by the petitioner. Full stop. Though the petitioner's names does not appear in the notice and some other name is appearing, comma, the identification and description of the land is that of the petitioner, and therefore the petitioners apprehend that they would be caused severe prejudice if any action is taken pursuant to the said notice. Puts the para. Issue notice returnable by 4 weeks. Sri Sri A. Bhattacharjee, Standing Council Revenue, accepts notice on behalf of respondent numbers 1, 2, and 3. Semicolon. Sri N. Goswami, Learned State Council, accepts notice on behalf of respondent numbers 4, 5, 6, 6, 9, 6, 9 to 11, 9 to 12, 9 to 12, huh? 3 as Bora for respondent numbers, Understanding Council GMC for respondent numbers, the Understanding Council for respondent numbers 7 and 8. And Sri A. Ganguly for the performance for number 14. Full stop. Let extra copies of the writ petition be served upon the learned counsel for the respondents by tomorrow. Full stop. Let notice be issued upon the respondent number 13 by registered post with AD. Full stop. Serves by tomorrow. Para. Heard the learned counsel on the interim prayer. Full stop. In the opinion of this court, comma, a prima facie case is made out as the eviction process has been sought to be done in respect of the land of the petitioners without the petitioners being connected either with the bank or with the transaction. Full stop para. In view of the same, comma, it is submitted, it is directed that that no coercive action, whatsoever, be taken so far as the land of the petitioners is concerned, which is the subject matter of this writ petition. Full stop. If, however, it appears that the action has been sought to be taken in respect of any other plot of land belonging to Messrs. Unison Infrastructure Private Limited, the same would be outside the purview of this interim protection. Your land, we are protecting you. Yes. Will come in 5 minutes.
Please, Your Lordship. In this case, Your Lordship, the petitioner is a land as having 2 bigger 3 quarter space of tract number 305 under Circle and District Tinsukia. By he has constructed a wall, boundary wall on his plot of land, tract number 305 to protect the sewage and rainwater of respondent number 5 and 6. But without hearing, and that wall was constructed as per with due permission from the Gao Panchayat, concerned Gao Panchayat, who is called, and no objection from the Gao Panchayat and said then. But without
The Gao Panchayat has the jurisdiction.
that area is Gao Panchayat.
No, is permission granted, is that authority, the Gao Panchayat, the appropriate authority to give permission?
It is called under the Gao Panchayat area also.
Understood, but is construction permission is taken, is required to be taken from the Gao Panchayat.
The village area, Gao Panchayat can take permission, building contract permission also.
Area may fall under panchayat, but
Ah.
ultimately
Acha.
the main authority is the
But
town and country planning.
yes,
Exactly, town and
Yeah.
country planning.
contrary, it is correct. But that impugn order, but I have constructed, they not close the road or not constructed any other person. I have constructed a boundary on my land. But now you will see that page 31 impugn order. That order is passed your Lordship,
Yes,
without,
you take instructions,
without prior notice or without any hearing your Lordship. That
take
order is passed.
instruction.
Till date, your
In
Lordship.
fact, Seriously, he has approved the report by way of a title.
That's withdrawn.
That is right authority.
Oh, yes,
No,
why did you withdraw the civil suit?
But truth is, there is no injunction is not granted.
So you have come here.
Not granted, and that authority has pressurizing me to close this period. Demolish this water.
Injunction is not granted, you will file an appeal.
So they are pressuring to demolish.
This is not something that you feel somewhere, then you come to the High Court. You come to the High Court by the hierarchy.
Because this year.
This is a civil dispute. You have approached the civil court rightly.
Not civility, it is
Injunction may be refused by the first court. It's a discretionary matter. Then you have the right to appeal. You file an appeal.
not. Because
at
in this
least-
case, the authority has pressurizing me to demolish it. Without hearing this notice is issued and without.
As Islam Learned Council for the petitioner who is aggrieved by a letter, by a communication dated 23/3/2023 issued by the Tinsukia Development Authority directing the petitioner to demolish, remove the boundary wall of the petitioner. Full stop. It is the case of the petitioner that the boundary wall was constructed over his plot of land and as per permission dated 28/9/2022 from the Dimoruguri Gao Panchayat. Full stop. He further submits that no prior notice has been issued. Full stop para. Issue notice returnable by 4 weeks. As Barua, Learned State Council accepts notice on behalf of restaurant numbers 1, 2, 3. Secretary of Government has 4. I think secretary will be PNRD. 4 is PNRD. Anyone from the PNRD? 4 and 1, 2, and 3. 3 as Dr. Understanding Council PNRD for respond number 4. Let extra copies be served upon the Learned Council for the respondents by tomorrow. Let notices be issued to respond numbers 5 and 6 by registered post PTD. Else by tomorrow. Heard the Learned Council on the interim prayer. Full stop. Considering the facts and circumstances and balancing the equities, comma, it is directed that till the returnable date, comma, the no further action be taken pursuant to the impugned communication dated 23/3/2023 issued by the Tinsukia Development. What is it? Tinsukia
Development Authority.
Development Authority. Returnable 4 weeks, just returnable on. Okay. Interim order is there, we'll fix a date. Returnable on 8th of May. 8th May.
Can be earlier.
28.
Ultimately, the complaint is that they're blocking the access.
No, there's no.
We'll have it on 28/2/8, 28/4, 28/4. Right, sorry. Yes. Mr. Bora, what is this?
May it please, Your Lordship, this is a petition. Your Lordship, basically, the NHIDCL and one company, Ramki TK Engineering Joint Venture Company, they entered into a contract agreement for four-laning of the section from Biswanath Saili bypass to Gopur. And in terms of that particular agreement, as per clause 9.2 of their agreement, the contractor was supposed to shift the utilities like electrical utilities, PHE pipes, all those utilities. And for that purpose, the contractor was supposed to engage some government registered contractor to remove those utilities of that utility owning agency. Now, in terms of that particular clause 9.2, which is at page number 38, Your Lordship may kindly peruse through that wording of that page number 38, clause 9.2. Just like to read it out, Your Lordship. Shifting of obstructing utilities. The contractor shall, in accordance with applicable laws and with assistance of the authority, cause shifting of any utility, including electric lines, water pipes, and telephones to an appropriate location or alignment, if such utility obstruction adversely affects the execution of works or maintenance of the project highway in accordance with this agreement. The actual cost of such shifting, as approved and communicated by the entity owning the utility, shall be paid by the contractor and reimbursed by the authority to the contractor. Here in this regard, the petitioner, he was engaged by the contractor by work order, which is at page number 40, dated 27/10/2015 for removal of the utilities of the APDCL. Since the petitioner as such is registered with the APDCL, he is a class 1 contractor. And the petitioner, he executed the works and he was paid the first RA bill. But in terms of this particular clause 9.2, the NHIDCL authority should have reimbursed the contractor and the contractor should have at first paid the petitioner. But they did not do so. NHIDCL, they bypassed that clause 9.2 and directly paid to the contractor instead of paying the petitioner. And the petitioner, he was paid the first RA bill in the year 2020, whereas the NHIDCL paid them in the year 2017, after 3 years. Now, with regards to the present status of the contract, they have foreclosed the contract and the contractor as such has submitted the final bills. And it has been approved by the utility agency, owning agency, as well as the authority engineer engaged by the NHIDCL.
Yes, Mr. Talukder.
There is first agreement. And contract was closed in the year 2020.
No, for his substantial prayer, we also have some questions. because his relief is sought against a private person. But he is taking help of a clause of the contract which authorizes or envisages a situation wherein the contractor can take the help of some third agency to shift the obstructing utilities. And there is also a mechanism how to pay. In the onus is upon the contractor, he'll be reimbursed. Now, he has not got the payment from the contractor. And now he says that if the entire money is given to the contractor, his chances of getting the money would be diminished, would be reduced. We may not be too inclined on the part of maintainability, but still will give some protection, take the instruction. No, no, no. No, 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 no.
Here,
No.
if I may,
That amount is under process.
If-
Because lordship, that after proposal of.
No, 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 you read the fifth line from the at page 38, clause 9.2, which we have understood, 9.2, the actual cost,
30.
page 38. Please read the actual cost. Read aloud, fifth line. 9.2, the
Cost of such. And reimbursed by the.
contractor and reimbursed by the authority to the contractor. The payment by the contractor has to be made first, then he'll be reimbursed. Now, his case is that he's not been paid. And in the meantime, the entire amount is taken. See, this is a discretion given to the contractor. He may do it on his own, he may engage third parties. He is also given the right, the contract also envisages, recognizes the situation that it can be given to a third party. It does not bar it. So he may do it himself, he may give it to third party. In case he gives to a third party, then he has to make the payment and get the reimbursement. Now, you may not be knowing that he is involved or not. But he is before this court that he is involved. You take the instructions, will issue short notice. Heard. D. Bora, Learned Counsel for the petitioner. Full stop. The yes, yes. Which one?
Not involved in this.
That you will not know. You may not know that he's involved or not. He doesn't say that he has a contract with you. He admits that the private respondent has a contract with you. And his claim is basically primarily against the private respondent, but the money will come from you. If 9.2 was not there, then probably we would not have entertained this. Now 9.2 will save him. You're a proprietorship firm or what?
Partnership firm.
The petitioner, which is a partnership firm, was engaged by the private respondent number
6.
6, who is the principal contractor with the NSIDCL concerning a work of 4-laning of NH 52 from the end of Biswanath Charili bypass to Gopur in the district of Sonitpur. Full stop. As per clause 9.2 of the conditions of contract, comma, the principal contractor was given liberty to engage for shifting of, as per clause 9.2, comma, the principal contractor was required to cause shifting of any utility to an appropriate location or alignment if such utility or obstruction adversely affects the execution of the work in question and the actual cost for such shifting, which was to be approved and communicated, would be paid by the contractor and reimbursed by the authority to the contractor. Full stop. The petitioner claims that it was engaged by the contractor for such utility work, as a result of which they had raised bills. Full stop. So some part of the bill was paid at the initial stage, comma, a major part amounted to rupees 2,21,08,249 is 34% of rupees so and so, is yet to be paid according to the petitioner. Full stop. The petitioner further submits that the work being foreclosed in the year 2021, comma, there is a process to settle the accounts by the NSID and HIDCL with the principal contractor, respondent number 6, and if that happens, comma, the scope of getting the scope of being paid for the works done by the petitioner would be minimized. Full stop. Para. Issue rule, issue notice, returnable by 4 weeks. R.K. Talukdar, Planet Standing Council, NHIDCL accepts notice on behalf of. Are you for one also?
1 to 4, Lordship.
Ministry of Highways,
Lordship, 1 to
as per numbers 1, 2, 3, and 4. Let extra copies be served upon him by tomorrow. Steps for service of notice upon the respondent numbers 5, 6, and 7 be taken by registered post AD. Steps by tomorrow. Why all of them made parties?
Respondent number 5 is the authority engineer. Respondent number 6 is the contractor, and respondent number 7 is the parent company of the joint venture.
They will get the money from whom?
From respondent number 6, it's a joint venture, but respondent number 6, 7 is the main company.
No, TK under no, 7 is not necessary because 7 is a part of 6, isn't it?
6 is a part of 7.
No, 6 is the JV.
JV, Your Lordship.
How can 6 be part of 7? 7 is a part of 6.
7 is yes, Your Lordship. I'm sorry. Your Lordship.
And STUP?
STUP is the authority engineer. They are consultants of the NHIDs. They have approved the work that I have completed the work.
May not be necessary, but still then, okay. Third, the learned counsel on the interim prayer. Full stop. 3. Bora, the learned counsel for the petitioner submits that if the amount is, if in the meantime, the accounts are settled with the contractor, comma, the petitioner would hardly have any chance of getting their entitlements. On the other hand, Sri Talukdar submits that there is no contract between the NHIDCL and the petitioner, and therefore there is no direction may be issued at this stage. Full stop. Para. After hearing the parties and on balancing the equities, it is submitted. It is directed that while settling the accounts with the principal contractor, comma, an amount of the amount which has been claimed in this petition, namely rupees so and so, should be secured, and no such payments be made without the leave of this court.
And bank guarantee also may not be released.
No, we'll have to stay with the security amount. Because their claim will be much more. You're only interested in 2 crores 21.
421. Highly appreciated.
Next. A Honecker is for whom? Private respondent. This is a 14 matter. When will he come back? See, normally we're not adjourn of matter of 14, but you send some emergency. Well, fix a date then. Let him come back. But otherwise, not granting any adjournment.
At least he should have mentioned it in the morning, my lord. Then otherwise I am waiting.
Those three PK Kalita London Senior Counsel for the petitioner is present, comma. A prayer for Sri what your name? MSC Decca London Council submits that informs this court that Sri A. Honecker, London Council appearing for the respondent number 3 could not be present, had to leave the station because of some emergency. Full stop para. Considering the above and also the fact that the writ petition is of the year 2014, comma, a small accommodation is granted with the direction to release this case for admission hearing on 28 20. That will be after the Bihu. Please.
My lord, in this matter, I was supposed to file an additional affidavit. It is ready for filing, but the deponent is out of station. So, lordship, my prayer, that it may be fixed for hearing. In the meantime,
15 matter, no. Not for affidavit.
lordship, it may be fixed for hearing.
We are hearing this matter right now.
Today, I have.
15 matter, we are not posting, we are posting this for hearing. We are hearing it right now. Yes, please.
Lordship, I did not do my homework, Lord.
Sorry.
This will be taken on 19th.
No, sorry.
I am not prepared at all, Lord.
Whatever is then we'll hear Mr. We'll record that you are not prepared and hear him. We'll apply our mind and pass orders. 15 matters, no adjournment. Don't even think of it.
The lordship delay was caused because the rate appeal was filed. So
Doesn't matter. Today has come for admission. Matter of 15 yet to be admitted, we are taking it for final request, final disposal.
then it may be taken at 2, lordship.
At 2 o'clock.
Meet please, your lordship, my lord.
Hmm.
In this matter, my lord, we have prayed for my lord to provide direction, my lord, to the respondent GMC to verify our bill and process the same, my lord. My lord, they have filed an affidavit.
You are claiming some amount from the GMC
Yes, my lord,
for works done.
for work done, my lord.
Bills are pending.
We have submitted the bill, my lord. They have not prepared the bill, my lord, on the ground that, my lord, we have rectified the dark wall, my lord, in absence of the site engineer, my lord. But, my lord, the work done by us have been admitted by them, my lord. They have filed an affidavit, my lord, although it was filed in 2019, my lord. But my lord, they brought some ground, my lord, that we like to reply, my lord.
Affidavit was filed when?
It was way back on
19, no,
19,
sorry.
my lord.
19 affidavit, we have not filed the affidavit till now, a reply affidavit. We're not allowing the affidavit to be filed now, 2023.
My lord. My lord, that page,
Yes, sir, have you verified, are you denying the work? How much is the amount involved, Mr. Dekha?
nineteen lakh, 1,776, my lord.
Concerning only the last part,
My lord, there are two parts, my lord. It relates to, my lord, from SS Road Junction to SRC.
now which part they are objecting that you have not done, or
My lord, in respect of a dark wall, my lord. My lord, kindly.
what is the amount involved there?
Well, for whole work, my lord, for first running bill, the amount is 19 lakh, 1,776, my lord. And my
No, no,
lord,
what we are trying to extract from you, that
yes, my lord.
as per your case, projected case, they are raising certain objections with one part of the work,
Yes, my lord.
isn't it?
They did not clear our bill, my lord. That, my lord, some portion of the dark wall, my lord, that we have rectified the defect, my lord.
Understood.
Yes.
For that, what is the amount involved, and for what is
For
the amount?
particularly that dark
Yes,
wall, my lord.
yes,
That, my lord, I have to take instruction.
because that may not concern the entire 19 lakhs.
Yes.
What is, as per you, is the amount admissible? Tabora? Even if we leave aside this amount, which may be a part of the dispute, the whole work you are not denying.
It's a part of 1,000 that have been.
In 19 lakhs, what we have understood is for the entire work.
This is the amount of first running bill, my lord. This is a running bill, my lord, first running bill.
Okay. Could you complete the work as such?
My lord, the work was allotted way back in 2016, my lord. It has already been completed, my lord.
No, no,
My
could
lord,
you complete the entire work, or was it, was a part of it was given to somebody else?
Lord, as per my instruction, my lord, we have completed the work, my lord, and the
So
entire.
if that is the first running bill,
Yes, my lord.
then you must have raised other bills also.
Since, my lord, it is not cleared, my lord. My lord, we have not raised any, and entire bill amount, my lord, will find at page 19, my lord.
We on the entire bill amount, page 19.
19, my lord.
How much is the amount?
This is the letter of acceptance, my lord. The entire bill amount, my lord, is 52 lakhs 98,131, my lord. That lordship will find it line number 3 in the first paragraph, my lord. Page 19.
Come to your prayer at page 16.
To verify the amount of rupees 19 lakh 1,007 raised.
No, no, come to your prayer at page 16.
16, my lord.
Prayer,
Here 1, my lord.
number 1. To
Right.
verify the amount.
Yes, my lord.
Hmm.
Against the work for construction, yes, my lord.
This is you are confining your amount, the entitlement only to this.
My lord, this is, my lord, in respect of the first running bill amount, my lord.
So that is what you are praying for.
Yes, ma'am. If they cleared this, my lord, then we can submit the other bills, my lord.
You have not prayed for any other bill.
Our prayer is confined only to, my lord, paying out the first running bill, my lord.
The prayer does not give that idea that is pertaining to the first running bill. It says work of construction of walkway in Fancy Bazaar from SS Road Junction to SRCB Junction. Where is the work order?
This is a letter of acceptance, my lord.
Where?
Annexure A,
Page?
19.
How much was the amount involved?
Amount was, my lord.
52 lakhs.
52 lakhs, my lord. Thereafter, my lord, after submission of the performance guarantee, my lord, at page 20, issue of notice to proceed with the work.
No, that is okay, 52 lakhs. But your claim is confining to rupees 19 lakhs odd.
Yes, my lord. This is in.
What is the reason? You did not do
Reason is,
the,
my lord, that we have not rectified the duct wall, my lord.
no, no, no. Why is the reason that you have confined your claim to
My lord,
19
kindly
lakhs?
come to paragraph 18, my
Now
lord.
you have not done the rest of the work or what?
My lord, we have done the work.
If you've done the work, why not the entire amount of 52 lakhs?
Paragraph 18, my lord. May I read, my lord, that the petitioner, while later dated 11/1/2018, informed the respondent that the rectification works relating to slabs and edges have already been completed and requested to prepare the first running bill of the petitioner, as well as to do necessary formalities for approval of the estimate for the work in question. Further, the petitioner assured the respondent to do the required rectification work if arises as per the instruction of the respondent.
See, this acceptance order letter at page 19 is of 24/2/2016. If you read the last two lines, please read the second paragraph
You are
rather.
hereby requested to furnish performance security plus additional security for unbalanced bids in term of ITB clause 28.5 in form of detailed para 32.0 ITB for an amount of rupees
So and so,
1,58,000
only
only
with
with 7 days.
from the receipt of this letter of access, valid up to 20 days from the date of expiry of the maintenance
Maintenance
period up to 31/10/2017.
Yes, ma'am.
That means till 31/10/2017, you are also required to maintain the
You
work
maintain
in
the
question. That means the work had to be completed in any case before 31/10/2017.
Yes, ma'am.
You have filed this petition in 2018.
Yes.
Either you have done the whole work, rest of the running amount bills have been paid to you, or you could not do the work, balance amount has been given to somebody, balance work has been given to somebody else. You are confining to your first reckoning account. What is the case?
My lord, my case is, my lord, they have not prepared the bill, my lord. In spite of I have completed the work, my lord. But my lord, in respect of lordship's query, my lord, that whether we have completed the entire work, my lord. Can I take instructions from my client, my lord?
Mr. Bora, any instructions? No, see, these are very rudimentary. We have to know first, there is a work which the value of which is 52 lakhs. He is claiming 19 lakhs odd. He says that this is the first running account bill. We want to know whether the entire work was completed, number one. If he has completed, whether he has been paid the rest of the bill. If he has not completed, whether the work has been given to offload and given to somebody else at his risk and cost, maybe. Then also whether he would be entitled to the amount of 19 lakhs for work which he has claimed to have done by him. But he also does not have the instruction regarding the rest of the work. And if this writ petition was filed prior to the completion date, then also we would have understood the matter. This writ petition was filed in a hurry, that time work was not completed. This is filed in 18. By the time the stipulated period is already over. Either you have done it or it has been offloaded. Take the instructions.
Yes, ma'am, that instruction I'll take.
You should come up with instruction 18 matters.
My lord, immediately after view vacation.
We are fixing this. By this writ petition, comma. The petitioner is claiming an amount of rupees 19 comma 01 comma 1 or comma 19,01 comma 776 for work done for a work which was allotted to the petitioner for construction of a walkway in the Fancy Bazaar area of Guwahati. Full stop. The work Guwahati by the GMC.
Yes, ma'am.
Full stop. Though the value of the work is rupees 52 52 lakhs odd, comma, the present claim is only of rupees so and so, 19,01,776. Full stop. Sri Dekha, the Learned Counsel for the petitioner, submits that the amount pertains to the first running account bill. Full stop. It is, however, not clear with regard to the fact as to whether the petitioner could complete the entire work and as to whether the rest of the amount was paid to him. Full stop. Accordingly, the matter is adjourned and directed to be listed again on 21st of April to enable both the learned counsel for the petition of Sri Decca and Sri S. Moral Understanding Council GMC to obtain instructions. Full stop.
My lord, is another writ petition, my lord, pertaining to remaining portion of the work, my lord. It is 4602 of 2018. It may also come up.
I think that will clear the issue. A list along with, is it pending?
Yes, my lord.
It along with WPC 46.
4602 of 2018.
Yes, next. 18. The Chamo, I think, is not well.
I'm appearing.
For whom?
Lordship, petitioner. Lordship, as per the order dated 26/2022. By
Yes.
this honorable court, a similar matter has been pending before this divisional bench. And the same has been listing on tomorrow for hearing.
Your name?
My name is PK Bhuya.
Sri P.K. Bhuya, learned counsel for the petitioner, has referred to the order dated 26/2022 passed by this court in this proceeding, wherein a reference to a writ appeal before the honorable division bench has been made. Full stop. The learned counsel submits that the appeal is related SLT there to be listed before the honorable division bench tomorrow, i.e. that is so. Tara. Also heard Sri S. Borwa, learned state council. Tara, in the interest of justice, let the matter be listed after 2 weeks. Full stop. The learned counsel appearing for the parties may apprise this court regarding the outcome of the writ appeal. You have taken the number? WA
185.
185, 2017. Yes.
May it please your lordship. Lordship, as per the last order, the matter was referred to the mediation. And accordingly, mediation took place and the matter has been amicably settled, your lordship.
Very good.
There is a report of the mediator, which is marked as flag M, I think, in the record.
Sri M.H. Lusker, heard Sri M.H. Lusker, learned counsel for the petitioner. Also heard Sri Argusami for
Respondent number 1.
for the respondent number 1, ICICI Lombard General Insurance Company Limited. Mr. Doctor for Sri S. Dutta, learned senior counsel, has appeared for the respondent number 3, IRDA. And Mr. Borwa, you are there? The learned counsel for the parties have directly submitted that on a reference made to the mediator for an amicable solution, the matter has been settled between the parties. Full stop. It is also informed that the learned mediator has submitted a report to the said effect. Full stop. Para. In view of the above, there is no live cause of action to be adjudicated and the writ petition stands closed.
I'm deeply obliged.
May it please, Lordship. Lordship, kindly peruse the last order dated 6/2/2023.
Six two, yes. Yes, vigilance.
Yes,
flood.
this month, there are lots. Inquiry was started. Finally, and now a report has also come in from the revenue and disaster management and also itself. And this, on the basis of this report, the office is trying to collaborate with the period that the office, so that if at all go there, then that will be the report. For that matter, just because of the on-screen budget session, some extra time has been for that will come thereafter. Then still was final. Now, section has also submitted and the very different. I mean,
When can you get back?
is now from the because of the one. To wait for.
Earlier, several occasions they have taken time. Last chance has also been given. Since long time they have taken time, Manat.
Is there any superlative of last? Big, bigger, biggest, last one, then?
That's has already been over, Manat, the last order.
What is the superlative term of last?
Last.
Yes.
I think we have to.
Last.
So what is the date of this? 2-3. We grant some time. But you take instructions when this budget thing is going to be over. We'll not adjourn just like that. We'll fix a date.
Yes.
We'll give a date. You just inform us, okay? Third. You try to get the information when this thing, budget session will be over. Our Islam Learned Council for the petitioners. The matters pertain to a claim made for supplies made by the petitioners as relief items during the flood in the district of Golpara.
No, Dhubri, man.
Dhubri.
Now such a man, sir.
In the erstwhile district of Dhubri. In
South Salman Mankasar.
In the present district of South Salmara, Mankachar. Full stop. The objection which was taken in these cases was that there were anomalies which were detected on which a vigilance case was initiated. Full stop. This court had directed the authorities to look into the matter as to whether the claim of the petitioner are within the ambit of the aforesaid investigation. Full stop. Though a number of dates were granted to obtain the said information, no concrete information could be obtained. Full stop. Today, Sri S. Barwala State Council has submitted that a written communication dated 2/3/2023 has been issued by the Revenue Department, as per which the inquiry made into the matter by the Commissioner Lower Assam was complete and the report submitted. And the matter was under consideration. Full stop. Here, however, due to the ensuing budget session of the Assembly, some time, some more time is sought for. Full stop, para. In that view of the matter, considering the above, considering the above, considering the above, and as an exceptional case, further time is granted with the direction to list this matter on, list these matters inside us on 10th of May. Enough time. You have copy?
Bacha. The Forest Department, your lordship, once it was heard, because my learned friend is raising a point of maintainability. Now, your lordship, remember, I found one judgment of the Supreme Court. I was really, when he said maintainability will be raised, your lordship also reacted. That I think with great respect, I found a judgment. When it is decided by division bench, party is same, issue is same. Now they cannot go into maintainability. It's a clear-cut judgment of Supreme Court. Oh, what?
Yes, Mr.
They can
Where is
go-
your senior? Who will be appearing? Mr. Gogoi? Let him come then.
I'm sorry.
D Gogoi or B Gogoi? B Gogoi. At
Because I think, my lord, your lordship will go through it. The judgment is, my lord, if I've seen the judgment already delivered by division bench, it said attain finality. If they are agreed by that, they can go for division bench. My lord, they want to distinguish one judgment of this honorable court. It's totally different, my lord. With great respect, I'm saying. And the learned single judge also dealt, coordinate bench of a lordship also dealt their judgment. And they said judicial propriety demands, when it is decided by division bench,
Correct.
it has attained finality. My lord, if they are really aggrieved, they can go for division bench. Maintainability point, I was just a bit of worried when they said maintainability. The Supreme Court made it very clear, latest judgment of 2022, they cannot raise. Kindly see. They
We
cannot
have
raise.
take a note of
It's
the
I
citation.
think that particular.
Take a note of the citation. In the break, you try to get the instructions.
They can, my lord, kindly see
Which paragraph?
paragraph 12, kindly see first. Paragraph 12. 12. Lordship got it, my lord. 2022,
Yes, yes, paragraph.
paragraph 12. Where an object to the maintainability of any applicant's suit on an issue of law is not expressly dealt with, but the application suit is entertained and disposed of on merit, the objection is deemed to have been rejected. The mere fact an issue may not specifically have been dealt with or reasons not specifically disclosed for decision on that issue would not vitiate a judgment order that is otherwise correct. Now kindly see 15, my lord. 15. Now in res judicata, the entire issue, 15. The principle of res judicata attracted when the matter in issue in the later proceeding directly and substantially being in issue in earlier proceeding between the same party in a competent forum having jurisdiction. Res judicata debars the court from exercise jurisdiction to determine the lease. If it had attained finality between the parties, there is a distinction between res judicata and issue estoppel. In the case of issue estoppel, a party against whom an issue has been decided would be stopped from raising the same issue again. Kindly see the last paragraph. 16. When an issue could have been raised. 16, my lord. When an issue could have been raised in earlier proceeding but has not been raised, the principle of constructive res judicata would be attracted to deny relief For it is not the policy of law that multiple proceedings should be instilled in the court in relation to the same cause of action, where the cause of action for initiation of proceeding is a distinctive cause of action, principle would not apply. My lord, they cannot. That's why I was bit of worried about. I thought, let me search and find it out. Mentability they cannot raise. And division bench, my lord, there's a judicial propriety manner with great respect determined. That's why when it came before the learned single judge.
We will try to hear.
Yes.
Ms. Putavaram.
Lordship will take up at 2 or when? When?
2 o'clock, 2 o'clock.
2 o'clock. Yes.
At least if we 6 for some time, that's a different matter. Otherwise,
Otherwise, I would have said, your lordship, my lord. The same issue, same, my lord, subject matter,
okay.
same party.
Yes,
2 o'clock, my lord. Deeply.
Who to next? Mr. Tiwari's matter. Yes, Mr. Tiwari.
Since it's a important case for us. Construction of dam, building of embankment, flood control measures.
But yes, we'll have it, but we have 2 matters.
But I understand
That Mr. Roy's matter.
But I'll try my luck.
Oh.
Otherwise.
No,
my lord, I
that
will-
may not take much time. That's
Yes,
an
I'll
old
try my
matter.
luck. I'll try my luck. Otherwise, my lord, I will pray for.
No, no,
short day.
this will try to give preference.
Yes, yes.
You said it's a very important for you to work in question.
NHPC is a infrastructure project. That is why
Embankment.
embankment, building of embankment, because it's a flood control measure
Okay.
connected with North Subansiri River. There is a stay order.
Okay. এতিয়া হ'ব নহয় জানো? SP Roy.
The petitioner for establishment of a mega cement factory has purchased lordship the plots of land. And after getting the approval from the state government, which was also approved by the high level committee presided over by the then chief minister.
Yes, Mr.
And
Anything? You're standing? You're standing counsel. Standing counsels are also allowed to sit. If you want to be outstanding, they have to stand out. Yes, yes. You are a company.
the land was purchased in the name of a
No, no,
company.
petitioner is a company.
Substance Cement.
Is it a company?
Earlier it was a company, subsequently it was converted to LLP.
LLP. Now you're an LLP.
The LLP.
Hopsam India LLP.
Yes, Lord.
You had purchased land.
I had purchased the land lordship by registered sale deeds, which was unfit for agriculture purpose. Lord. And those sale deeds I have annexed lordship and sale deeds, your lordship, may be pleased to come to page.
What was the status nature of the land?
Status of the land, it was agriculture as per the earlier Jamamandi. But it became unfit for agricultural purpose because it remained submerged throughout the year under the water.
But initially it was agricultural land, but not fit for agriculture.
Not fit for agriculture, and there is a government circular lordship that if the land or not used for 10 years for agriculture purpose, then it should be industry should be granted permission.
Okay.
For establishment of the factory. And now your lordship may please to come to the sale deeds by which
How much land did you purchase?
land purchase was almost 147
147 bighas
bighas.
for establishing of the factory.
Factory lordship, mega project of by investing more than rupees 130 crores, which was duly approved by the High Committee, Industry Department, Central Government, all
Okay.
this.
Hmm.
So lordship may come to page 46, which is the Jamabandi and thereafter sale deeds. Page 46, Lord, 46.
Yes, yes.
This annexure 9 lordship, page 46. On the bottom, your lordship will find that the land was after purchase, it was mutated in the name of the Topsam India Private Limited lordship. So the land was purchased by the company lords,
Yes.
and sale deeds are just beneath this lots. Lots may come to page
Doesn't
Page
matter, doesn't matter.
50 lot.
At 50 onwards.
50 or not are all the sale deeds. And this sale deed also shows lordship page number 52,
Yes.
that the land was purchased, page 52, in the name of Tops of India Limited. Company lordship, not
Yeah.
in the name of Bajrang Lohia. Bajrang Lohia is only one of the directors. So a directors cannot act individually lordship until and unless there is a resolution by the board of directors of company as per required under new act of
Companies Act, yes.
section 179 of the Companies Act. Lordship. But no notice was.
So what is the problem now?
Lordship, they had, the DC has given a notice by which he has directed the circle officer to take the possession of the access land beyond 50 feet. Lordship, without determining any compensation, without issuing any notice to the company lordship, and in the
Under the Ceiling Act.
under the Assam fixation of stealing online holdings in 1956. No notice was given to the company, which is the honor of the. Nothing. The notice, first notice, your lordship, please to peruse. The
That act should be applicable.
the act will not be applicable because act applies only in case of agricultural land. If a land become unfit lordship, our own high court judgments are there. If the land is not fit for agriculture.
And when did you purchase? In 2008?
Lordship,
When did you purchase the land? 2008?
yes.
8 onwards, is it? No,
No, I purchased the lordship.
it's 2008, 9,
Yes.
that period only.
Sale deeds were purchased lordship.
2008, 51, page 51. 10th of April.
Yes, sale deeds are lordship. 2008. 2008.
Where is the impugned order?
Impugned order is lordship. Page lordship 40.
40.
And surprising thing is this, the collector has not filed any affidavit in opposition. No draft statement was prepared, no final statement was prepared, lordship. Nothing mentioned which patta number, dag number has been declared as a ceiling surplus lordship under the provisions of the Act of 1956. Simply, lordship.
Page 40,
Page 40, annexure 4.
impugned order.
They have served such a copy which is not clear at all. Nowhere in the impugned order.
So what is the ultimate substance?
Ultimate substance lordship, while
And of the impugned order?
Improving order that lordship may come to the.
Take possession.
Next page, 41.
Or to take possession of the excess
Yes,
land.
circle officers, Nagpur circle accordingly take possession of the excess land measuring 92 bighas, 1 kata, 4 letter and correct the records as per government, as government land. This is the order. As per the provisions of Act of 1956, lordship, first of all, a draft statement is to be prepared and served to the landowner. Then the final statement is to be prepared and served to the landowner.
You're basing your challenge on the procedural aspects, or you're saying that the entire action of taking over
Action is a nullity, lordship, without jurisdiction. Because lordship, we feel to-
for not following the procedure prescribed.
yes, as well as lordship procedure prescribed, as well as lordship. No,
Are you raising the issue of applicability of the act?
no, lordship, when the notice was not given to the landlord, lordship is pleased to peruse the first annexure, lordship. That is page 29, lordship. Page 29, no notice has been given to the company. The notice,
What is the date of the impugned order?
date of the impugned order is lordship 20th of May 15.
Where do you get?
I received lordship.
Oh, 20th of May, given a hand and seal.
And see the notice, lordship. Page 29, annexure 2.
Page 29.
Yes, lord.
Yes.
It is dated Neil, lordship. On the right side dated Neil. Addressed to Bajrang Lohia. He is not the owner, lordship. Owner is the Topsem Limited Company, lordship. This is sufficient to pass the impugned order, lord. Because landowner was never given any notice. It has been reported by the circle officer that excess land measuring 92 bighas, 1 kata, 4 lecha has been transferred to you in village number so and so, Ojari and Sonabor under Dimoria Moja, Sonapur Avenue.
Let us see
Circle.
the Assam Fixation of Ceiling Act 1956.
Lordship,
Let us see the act. What is section 20?
section 20.
Hey, here you can't like land. 1956 Act, Assam Fixation of Ceiling. Working on it, index of ceiling on land holding. नाम होने Assam Fixation of Ceiling of Land Holding Act.
अरे एक निकालो. What volunteer?
Yes.
Yes.
Section 20.
I could not do my homework, Lord, because there are some personal difficulties. Page 1, yes. Section 20, Lordship. Contents of the declaration under section 20 and the action to be taken upon it. The declaration to be made under subsection 2, section 20 by a transferee shall be filed in the duplicate and shall contain the following information: the plot number, area of the land under the transaction, name and address of the transferor, name and address of the transferee, the total of land already held or purchased by the possessed by the transferee or any member of his family as owner or tenant, the plot The plot number, location, and any other additional information necessary to identify the land mentioned in D above, and where they are held jointly with any other person, the share of the transferee or any member of his family. F, any other information not inconsistent with the above as required by the registering authority or the collector or any other authority in this behalf, as the case may be, before whom the declaration is required to be filed under the provisions of section 2 of section 20. Where the registering authority takes action under subsection 3 of section, which will retain a copy of the declaration in his office for record. See subsection 3, where the registering authority does not take any action under subsection 3 of section 20, he shall, after registration of the document evidencing the transaction, forward 2 copies of the declaration to the collector or any other officer authorized in this behalf. For subsection 4, the collector or the officer authorized shall send one of the copies of the declaration received from the registering authority under the foregoing rule, or a copy of the declaration made before him under proviso to subsection 1 of section 20 to the settlement officer or the circle sub-deputy collector within whose jurisdiction the land under transaction is situated, and if the settlement officer or the circle and sub-deputy collector finds that the actual area of the land already held by the transferee is greater than the area shown in the declaration, then he shall report the collector or the authorized officer giving particulars of the land actually held by the transfer. The present, this is section 20, Lord, which has nothing to do with the declaring a particular plot of land as a selling surplus. And see, already I have submitted, Lordship, on this notice.
No, section 20 has referred to section 4.
Yes. Section 4 and section 20 very clearly state that giving the dag number, patta number, and the area of the plots of land. Nothing, Lordship, such a vague notice has been given. And this notice has been given under Rule 21 laws.
No, 20, the interpretation given by you perhaps may not be correct. This lays some responsibility upon you that if you are purchasing land which is in excess of the land mentioned in paragraph section 4 of the Act, then you are required to give a declaration.
Yes.
That this is the amount of land which I possess, and the declaration has to be duly verified. This subsection 2.
That is, your Lordship is very correct. But where, my Lord, the owner, when the notice was not given to the owner, company Lordship, where from the company will give the declaration, Lordship?
No, that is not, there is no question of notice in section 20. If you don't have the book, I think.
I am having it.
Subsection 2.
No, Lordship, section.
Subsection 2.
Yes. Section or rule, Lordship?
No, we are on the Act section.
Act.
Section 20.
Yes, yes, yes.
That is because the impugned order mentions about section 20, isn't it?
Yes.
We have to go by section 20.
No,
There is no question of
read out the
notice.
Rules 20.
No, you're reading the rules. That is why we thought there's some problem. Come to section 20.
Section of online.
আমার আরো এখন আছে Assam Fixation of Ceiling on Holding Act 1950 সৰু কিতাপ ওইখন পঢ়িব You have the act, this bits 20.
Any member of his family.
The section 4 has already fixed the limit, 50 bigger. Now you come to 2. First, you cannot go for plots of land which is more than the ceiling fixed in limit fixed in section 4. Then come to subsection. When we will come to that later, you come to 2, subsection 2. See, the onus is upon you to give a declaration that you do not.
No notice has been served to the company.
Where is the question of notice here? This is a precondition. Which notice? Where is the concept of notice under 20? 20 says that if you possess land which is more than the limit, or if you are possessing land, just to be within the limit, you have to give a declaration. This is the land which I already possess or own. No, that situation is also envisaged. The situation, even when no registration is not required, that is also envisaged. Then you have to file the declaration before the collector or the officer authorized by him. See the proviso, provided that in case of any transaction where it does not require registration. Where is that? What is that decision you'd like to place? 2017, you have said.
Mr. Kamrup Metro.
Page 3, paragraph 6. Yes.
The public limited company raised Petitioner. That the Honorable Guwahati High Court by order dated 1/10/7. In PIL number so declared that the registration authority. Is same order, the Honorable High Court also declared documents requirements of the registration. Objection certificate without necessary legal support requirement. Sir, passing of the said order by the Honorable Guwahati High Court.
How is this relevant?
Relevant is.
We are on the point of declaration by you.
Generally declaration is given at the time of.
No, this declaration is a necessity under the 1956 Act.
Yes.
Where is your compliance?
Where is.
If it's not there, then you are violating section 20.
Then notice for that a notice is to be issued. Notice has been issued in the name of a person who is.
See, that is your second leg of argument. That will consider. But
From that lordship, the government.
you say that the notice has been issued in the name of one of the directors, not in the name of the LLP or the company. So it is not.
Director has not been written in the notice, only Bajrang Lohia. In what capacity lordship? Partner or is a director, there is nothing lordship.
No address also is.
No, nothing, no address, nothing. Suppose lordship, I did not give any declaration as required under the Act of 1956. Then, as per the Act of 1956, lordship, you have to prepare a draft statement, lordship, in any ceiling surplus matter, lordship. It is to be served to the.
We'll just come back to you. Mr. Mazumdar, what is your immediate direction?
Person. Or. They are transferring. After then found that best government comes 7 by.
No, the action is against the petitioner.
There is no personal action. Legal. That is why second.
Are you trying to indicate that to circumvent the process of the act, the original owner had sold land because he had land excess of the limit under section 4 to overcome the application of the act, he had sold that. And what would be the protection to a third party who buys for bona fide consideration? Who purchases for a bona fide consideration? No, that 20, that declaration will come when then, 20, that 20. It will not come for the, will it not come for the petitioner? The requirement under section 20, that when you are trying to future acquisition of by transfer. No, what is section 20? This is a non-obstante clause. It will override. Okay, understood. No person. Yes. That means a person who has land, he cannot acquire or possess more land more than the limit fixed. Now that is not for the owner, that is for a land. Now he has purchased land, which. Yes. No, that he cannot possess land more than the limit fixed. And for that he needs to give a declaration. That I have 10 bighas, I am buying another 10 bighas, which is less than 50 bighas. That is it. He was required to give a declaration that the petitioner. Owner was not acquiring land, petitioner was acquiring land, possessing land. Where is it required? Under which provision? It's certainly not 20. There may be some other, but not 20. 20 is person if he's purchasing or acquiring land is not exactly prohibits. It's a kind of a check and balance mechanism that if I acquire or possess land, that should not exceed the limit of section 4. For that, I need to give a declaration that I already have 25 bighas. I'm purchasing another 25 bighas, nothing more than that. Yes, please read. Yes, future acquisition. Shall. Yes. The aggregate exceed the limit of section 4. That means if he did not possess any land in earlier, the land which he is acquiring should not exceed 50. Or if he is having land earlier, then the aggregate should not, the total should, that is the declaration he is required to give under 2. C2, 2. No, C subsection 2. Unless. See. Before I possess, I intend to purchase. Before registration, I have to give a declaration that the total possession is not exceeding section 4. That is upon the person who is purchasing. That is the reason 20 has been incorporated in the notice. He did not give such a declaration. Yes. That means any transaction made by violating 20 is non-est in law. That will not vest any right upon the transferee. Now, suppose assuming at 20 is applicable, 21 is applicable, then what is the procedure prescribed? Aren't you required to give a notice? No, to what Mr. Roy is saying, that it is to one individual who is not even described. How is he connected with the? Oh. Reply given. Mr. Roy, if notice is replied, the question of prejudice will not come.
No, Lordship. The company which holds the land did not give any reply, any so-called. Lordship. I have annexed.
Where is the notice reply?
It was given by annexure. Page 30. 29 is the notice given by the Deputy Commissioner to one Bajrang Lohia.
Where is the reply?
Reply is Lordship at page
30.
30. The first para itself, Lordship, of this reply is that the notice has been issued in the name of Sri Bajrang Lohia, who is not the owner of the land measuring at 92 bighas 1 kata 4 lesser. That is ceiling surplus.
But you did not stop there. You did not stop there.
No. I have.
You had gone into the merits and had made a 10-page reply.
Yes. 10-page reply, Lordship. I have also disclosed that the owner is the Topsem Limited Company, Lordship. And no notice has been issued to it. In spite of that, Lordship, nothing was. And apart from that, the facts are these, that the government high power committee headed by the Honorable Chief Minister, Lordship, directed the DC to convert the
But Mr.
land.
Mazumdar, Mr. Roy may be correct in his governmented paragraph 1. He has made it clear that a notice has been issued in the name of Bajrang Lohia, who is not the owner.
Everything was done hurriedly due to agitation done by Mr. Akhil Gogoi, KMS's Lordship. Thrice he had tried to attack the directors of the houses or Lordship. All documents, many 4 or 5 FIRs were lodged. Under his pressure, these things were done. I have stated everything. And when the Higher Revenue Authority, Government of Assam, Chief Secretary, directed the DC repeatedly to that this is a mega project and the land should be immediately converted to the for industrial purpose, Lordship. And such directions were given in 2014, Lordship, but the DC never complied it. And my cell dates are of 2008. Lordship, I may be allowed to place the government direct orders.
Yes.
Yes. Page, first of all, Lordship, please to come to page 76. Page 76. Because Lordship, the precondition for exercising the power under the Act of 1956 is this, that the land must be cultivable land. That is the finding of the full bench judgment of this honorable court.
Let us see. Let us see.
Just, I am having.
Should have come.
Lordship, may please to come to page 76.
Mazumdar,
Yes,
we'll have it on 20th.
Lord.
He wants to show some decisions, he is not prepared. We come on 20th, but 28th for final disposal.
okay.
Huh?
Saturday,
19th is a Wednesday.
My all family member left tomorrow.
Okay,
That
19th.
was my personal difficulty.
19th. But you give the list in advance so that he is also prepared. What is the present status now?
We are in position. Because they have not determined the compensation as required under the Act of 1956, nothing else, Lord.
If you are also agreeable for compensation.
No, I have not claimed for compensation, but I have taken.
No,
that-
no, if you have an alternative player, we are not saying that we'll not entertain. We can seriously ask them to assess the compensation. Or whether compensation will at all be payable, but something you can get, because this is not an acquisition proceeding. As per the act, land will not vest upon him. Government. Settle the tenant under which act? 71 act? No, so not this act itself.
Act 56 also provide lordship.
Now, where is the requirement of agricultural land?
No, if Lord.
The act provides certain exceptions. It has to be a farming corporate, then tea cultivation, special cultivation, or a cooperative society engaged in farming.
Lordship.
There are 4 or 5 exceptions.
Sections 7 and 4 lordship on its conjoined reading reveals that 50 bigas individually as per family. If it is a partnership firm lordship, all partners will be a distinct entity family lord. And each will be entitled to hold. 50
Not individually. I think it is
I'll
made.
come.
Okay,
I'll come
In the-
individually in the.
that is
act-
not the purpose of the act. Act makes it clear. Oh, family, yeah. Oh. On 19th. On the prayer of. Do this matter is of the year 2015. Comma. Three SP Learned Counsel for the petitioner has paid for some accommodation. Full stop. Also heard Sri D. Mazumdar, Learned Senior Advocate and Additional Advocate General Assam, assisted by Sri N. Goswami of Tara. Considering the above, that the matter be listed again for admission on 19th, 19/4. 19/4. 19 will complete.
Oblige. He didn't take up.
I take over time. Huh? Doesn't matter. Hmm. Hmm. Yes. No, sir.
One
I don't know, it's taken.
issue is here, my lord. My lord, if my learned friend is aggrieved with division bench judgment, he should go for division bench, review this order. That is attain finality, my lord. And coordinate bench also has distinguished the judgment, my lord.
No, he's raising an issue of maintainability because of
No, it cannot be raised. That's why kindly see the judgment, my lord.
which one?
Kindly see the judgment. How can he raise the maintainability issue
Which
at
judgment?
this stage? The judgment of 2022. This is what I have.
Now, was it raised earlier?
I'm sorry?
Was it raised earlier and negated?
No, it's not necessary also. He
No, no,
cannot
no.
raise now.
This judgment says that if
No,
any, no, you have placed the judgment, we have read it.
Yes.
We are agreeing with you, whatever you have said,
Yeah.
that if a point is not even decided, that has been deemed to be decided and negated.
Yes.
Now, you have to show that in the earlier proceedings, the question of maintainability was there. And
If it is not raised, earlier it is not raised. Now he is raising for the first time. The issue being the same there, exactly is the same. He cannot raise now.
which is the earlier case?
Earlier case, that's case what the division bench of this honorable court
81.
raised 81. How can he now say that that judgment is wrong? 82, 81.
Page 81.
Yes. Same party. Same department. Contract is same. 81. Page 81
81.
of my writ petition.
Yes, yes. Yes.
Kindly see, my lord.
Hmm.
The division, the state has gone before the division bench. Again, the
Right.
order will run a single judge.
Yes.
Kindly see, my lord. State of Assam, represented by the commissioner, same PWD. Number 2, Commissioner of Special Secretary,
That is
PWD.
okay. But what was the nature of the contract? Same
Kindly see,
contract?
same contract, not even a single word difference. That's why I'm pointing out, is exactly same. Exactly same.
What was the relief claimed by
Same
you?
relief. That's a forest royalty. They have deducted. It was not a part of the contract. That's 17/6/2000. Now this again judgment was tested. The same judgment which my learned friend, your lordship, has put a query into it, that there is another judgment. That judgment has been tested by coordinate bench of your lordship. Kindly see the judgment. Kindly see the judgment. Yes, sir. I give you one. Why you so much? Yeah, your lordship is holding the judgment, RC and construction. Yeah, I think it's a given there. Where is my file?
Yes, sir. Arsen is here.
Yes. Kindly see RC and construction, my lord. And kindly see the issue. Muslim Ali division bench, my lord, at page 53. Kindly see, my lord. My lord, your lordship will be better is in page 60. Page 60 stroke 72.
Yes.
Kindly see 14. Answer to issue number 1 and 2. The judgment in Muslim Ali, Supra makes it clear, absence of any contract condition, recovery from contractor bill cannot be made against forest royalty. Regarding the OM dated 17/6/2000, issued by the Finance Department, it was specifically held, such OM ought to be specifically incorporated as one of the contract conditions to enforce the same or to take benefit of the same, otherwise the same is not permissible. It was concluded that as per provision of Mines and Mineral Rule, it is a responsibility of mining list to make payment of the forest royalty and is not the obligation to be discharged by the contractor in absence of any specific provision incorporated in the contract. Such view was affirmed by the Honorable Division in much as Pinoy and Associates, Supra, and all some subsequent decision of the coordinate benches. Decision in Muslim Ali has thoroughly been followed. Now kindly say, in Durga Krishna stores, a specific clause was inserted in the contract itself, with a stipulation that whenever forest produce like sand, stones, timber, etc. used in the works, contractor will have to furnish documentary proof that requisite royalty on such produces have been paid to the concerned department. It was a finding of the Honorable Division Bench in Durga Krishna stores that in view of the mandate of the OM dated 17/6/2000 of the Finance Department, such clause was incorporated. That's the difference which has not been incorporated in our clause. Therefore, the considered opinion of this court is that there is no conflict between the judgment in Muslim Ali Supra and Durga Krishna stores Supra. The basic principle laid down is that Office Memorandum of Finance Department dated 17/6/2000 is binding in nature and that such notification can be enforced or such notification can bind the contractor. When the condition therein are specifically incorporated in the contract, therefore, it can be concluded that OM dated 17/6/2000 shall be enforceable and shall be binding in nature when the employer department like PWD, Railway, etc. incorporate the same in their contract. Otherwise, the same will not bind the contractor. In fact, in Trina Associates, a specific direction was issued to the effect that henceforth the clause of OM dated 17/6/2000 shall be incorporated in the contract. However, it is informed such clause has not been incorporated in any other subsequent contract. Same year, it is well settled that to maintain certainty, stability, and consistency in the legal system, the court generally abide by the things issued already decided. Legal principle or rule that should have been created by the earlier decision of this court should be respected and followed. Touching, that's what I am saying, my lord. Touching similar legal issue and the same should guide the subsequent decision. Court must follow decision made earlier in subsequent cases where the same legal issues are brought before it. In case of so-and-so, this court so-and-so similar case. Now kindly see, my lord, at next page at paragraph 8, Roman 8, as discussed herein above, the principle is settled by division bench in Muslim Ali and has been followed by all the coordinate benches in many cases, and the same has now been settled. So far relating Durga Krishna, the same is decided in given facts of the said case. In the considered opinion of this court and the discussed above, no law has been laid down in the said judgment that OM dated 17/6/2000 is binding upon all contractor in absence of any contractual clause in as much as the contract clause was very much available in the contract that was subject matter in Durga Krishna. Therefore, this court is bound by the decision of Muslim Ali, and at the same time, this court is in total agreement with the principle laid down in Trina Nation followed in subsequent cases. So all this is very clear. Now kindly see, my lord, at page 68, 72. 17, my lord. Yes, page 768. I think my learned friend was there, if I am not wrong. Page 68/72. As 17, kindly say. Effect of incorporation, same mile, OM, dated 17/6. Let this court now consider argument of Mr. Gogoi, learned counsel, who urged that those contract agreement where the Office Memorandum of Finance Department dated 17/6/2000 is a part and is signed by both the parties need to be treated as a contract term, and according in those cases, state employees liberty to treat the same to be an express term of the contract, and accordingly, in those cases, the OM dated 17/6/2000 shall be enforceable binding. Countering such argument, Mr. Chaudhary learned senior submit such issue has already been decided in Muslim Ali by holding that the stipulation made in OM dated 17/6/2000 needs to be specifically incorporated as a contract clause, and then only the same can be treated as contract condition. His further submission, even otherwise, when the source of procurement is mandated in the contract to be through permits under MMC Rules 2013 or under Forest Regulation 1891, then only the OM dated 17/6/2000 can be implemented, which is not the case in the present batch of the represent. Therefore, he argues that until and unless procurements mandated to be made in the contract to permit, etc., even incorporation of OM dated 17/6/2000 as a part of individual contracts shall not help the authority in view of decision of the Muslim Ali. It is in the considered opinion of the court in Muslim Ali, the learned single para 8, 9, and 10 held that to enforce OM dated 17/6/2000, there must be a contract condition that the contractor has to procure the material from a particular government quarry Otherwise, recovery shall be unauthorized. The Honorable Division in the judgment passed in Muslim Ali specifically quoted the aforesaid paragraphs at para 17. It was specifically expressed, division bench on the agreement with the finding of the learned single judge. In view of the aforesaid, this court finds force in the submission of Mr. Chaudhary, learned senior counsel, and reject the contention of Mr. Gogoi, learned standing counsel in the given facts of the present batch of and issue settled by division bench so and so. So it's a question of now. So my once let me complete. Why you are getting so excited to understand? Why he has to
Take a seat.
yes. So whoever may be, my lord, it is only decided by this court. My learned friend cannot improve with great respect. He has some issues regarding about Muslim Ali in this case, exactly on the same point. My lord, my learned friend has to go for division bench. They review the judgment. It's my lord, with great respect, I am saying, this is a judgment of a division bench. Now, going to the judgment of this court of 2022, kindly see, my lord.
Mr. Das, the issue of maintainability, we may not seriously go into. He wanted to raise it, we had permitted him to raise, but otherwise, the writ remedy in case of a contract like
No.
this,
Yes.
excluding that perhaps
No, my lord, I
it's
think.
too late in the day
I
to argue
think-
on
I
that
think
point.
this judgment,
But we are on a different aspect.
my lord,
The
this-
difference,
I lord, distinguish, my lord, have.
yes, distinguishing.
Distinguishing have your lordship has said. If my learned friend can.
No, this
show-
judgment which
No,
you have shown,
If my learned friend can show that this is a separate case, we can distinguish. This is a separate case because your case, my case is distinguishable. And it is not connected with the judgment of Muslim Ali. I have nothing to say, man. I know my limitation. I will not mislead this court. I
obviously,
am
no.
telling with my lord, with authority that this judgment is exactly on the same point which we are, my lord, is now judging. The judgment of this case, my lord.
So in the case of RCN, the coordinates bench had gone to the aspect of stating that in Muslim Ali and Durga Krishna is distinguishable because in Muslim Ali, there was no clause in the contract,
Correct.
which is
Right.
there in Durga Krishna.
Right.
And in absence of a clause in the contract, they cannot go
Yes.
ahead.
Because
That part, you may
this
address
part,
this.
my lord, this part was also raised. This part, but the learned single judge coordinate disagreed. We cannot agree to it. Already that is confirmed, a judgment of a division bench. My lord, what my learned friend is saying, is like a review of a judgment of a division bench. I think, my lord, I have gone 10 times about the judgment of, I also thought, let me also go to RCN construction. Let me go to Durga. Each and every line I have gone through is nothing is different. You cannot distinguish. With great respect to my learned friend, I am saying, cannot distinguish the judgment. And it is a settle, my lord. There is not even a clause which is different. I read each and every clause of the agreement. Not as different, my lord, at the same clause. Exactly a ditto clause, my lord. Agreement, which was executed between us and between PWD. Same. The lordship will not find a different clause at all. Kindly recall the judgment, recall the division bench and see the petition and see. My lord, all the time, Forest Department, PWD, my lord, even knowing fully judgment, the same thing Forest already deducted. And it is an opportunity for us that we are appearing, my lord. The client says, what is this? Judgment has been passed. Even then again Forest Authority. In not, I have annexed all the judgment of the learned single judge, same party. Again, he is doing the same contractual matter, again for his deduction. Single bench says, kindly see, I have annexed. Kindly see all the judgment which I have annexed of the learned single judge. Even after passing of division bench judgment, my lord, kindly see page 91. Same party. Same department. I would understood there is a different department, same department at page 91. Page 91 kindly be seen, my lord. Same party kindly see. Department is same. 93 kindly see, my lord. 93 now second paragraph. It appears that in the case of Muslim Ali versus State of Assam and others registered in writ appeal and a batch of connected proceeding in a division bench of this court was held, no appropriation of money from the contrary would be permissible unless backed by statutory provision. And what is the last paragraph? In view of I dispose of, respond directly refund a deducted amount. I have annexed. I'm conscious, I don't want some judgment should be, we also should assist the court, my lord. When this, my lord, Durga, I never knew of Durga. When it was pointed out before the court, I have noted down each and every paragraph, my lord. I could not find any distinguishing to distinguish the present case. My lord, suppose my learned friend is aggrieved. My lord, the only way he has to go before a division bench. With great respect, I am submitting for lordship. They are not agreeable with this. What they could have done it, they have to incorporate it, which in the present case also they have not incorporated. 17/6/2000 memorandum, my lord. It should be a part of that particular incorporation. It's not there till today. Let them say, my lord, in the agreement, something else is there. Let them say. Now my learned friend cannot interpret. Now my learned friend is trying to interpret. Even if it is not there, he is bound under the statute which has been laid down. Now then he has to go before a division bench. Division bench said, review this order. So already it is settled by division bench, my lord. That's why the coordinate bench says, my lord, this Durga was brought before this court. But disagreed. But this is a settled position of law. You want to unsettle it. Yes, you want to unsettle it.
Come back to it.
You have to unsettle it for this particular law. And he wants to interpret that even if there is no clause, or even if there is no clause which is incorporated, 17/6/2000 by other laws which governs under Mines and Mineral for Concession Rule or the Forest Regulation Act. So that is implied. So please review this judgment. I think he has to approach the division bench. I was showing this judgment, my lord, of this 2022. It's a settled position. It's been decided. Can it be reopened? Mentability, he was raising mentability.
That point we are not
Yeah.
too much inclined.
But no, my lord, I'm just asking question myself. Can my lord now, can the Muslim Ali, let me, your lordship is directly reviewing that order? I'm sorry to say, my lord, if you reviewing that order, your lordship sitting before a single bench, your lordship will review a division bench order because of the law which my learned friend is now going before this court. They forget about 17/6/2000. What the legal position which my learned friend want to now distinguish it. There are other provisions. Please look into it. Division bench has not has looked into it. My lord will look into it. This is what my learned friend is trying to say. And I could have very well understood if this clause, there was some incorporation as like what is that, that Durga, situation would have been different. It is clearly mentioned about that clause which is incorporated. Till today, my lord, they have not incorporated that clause. Let's see that clause, nowhere it is mentioned. Same, exact same. They can go before, absolutely there is no problem. They can go for division bench. Let them go for division bench. It is only a division bench who has passed this order, my lord. Because my coordinate bench, if your lordship takes a different view, the coordinate bench has already taken that view. That was passed. Not only Muslim Ali, there are other cases also, my lord. Division bench has decided, 3-9 has decided, my lord. So many cases, now learn a single judge. Coordinate bench has decided, my lord. There are a lot of, my lord, this annexure in this case, a lot of single bench who has decided. Same subject.
Come to page 86.
86. Yes.
Paragraph 16.
Paragraph 16. That the Office Member of Finance Department dated 17/6/2000 provides that bill of contractor engaged in construction work of government departments and government undertaking using forest bodies will not be paid unless the forest department certifies forest produce for utilized has been collected from legal source and necessary royalty has been paid. The same is not a condition incorporated in the contract agreement and therefore would not binding force on the contractor.
Would have no binding force.
That's
Then you
that's
come
it.
to page,
Now, kindly say 17, my lord.
then you come to page, paragraph 18. at
Paragraph 18,
Page 90,
page 19.
90, 90.
190. We are in agreement with the views expressed by the learned single judge. No appropriation of money from the contractual due is permission unless backed by statutory provision or by express provision contained in the contract agreement, binding the parties to the contract. In absence thereof, such deduction would be unauthorized.
What
None-
about we are here, what about the statutory provision?
No, I understand. Permissible under, well, if that be the case, your lordship is a judgment by division bench. That
No.
means your lordship is
No, no.
over it.
Division bench has also said in paragraph 18 that unless there is a statutory provision
Or
or
express
express
provision
provision contained in the
contained in the
contract,
contract agreement
there is
binding the parties.
there is no such provision in the contract.
Yes.
So what we are left to examine is whether there is any statutory
No,
provision.
then my lord.
We are not going to the office
I know, by
memorandum.
your lordship, that means your lordship.
No, we are not going to the office
I know,
memorandum.
but your lordship is going by back by statutory provision.
Yes.
Your lordship is reviewing the judgment.
No, no, of course
Oh,
not.
yes, same
No. How
clause.
can we review a judgment?
No, I'm
Then you
sorry.
did not remind us twice.
No, I'm sorry.
We
my
know
lord.
about our limitations.
No, I'm sorry, my lord. What I'm saying,
The division bench has said that if there is a statutory provision
yes,
for such deduction, then it can be done. We are also aware of the
my
fact
lord,
that 17/6/2000 has been held in implied terms. That it is not a statute. Obviously, it's not a
Can I
statute.
give an answer to it? my
Yes.
lord? Can I give an answer?
Mm.
My lord, at that time, when it was decided by the court, when division bench was in session, that also they also aware of that some statutory provision or by express, even the division bench has not interfered. That time the law was there, my lord. The PWD could have pointed out before the court. If there is no express provision also, there is some step backed by statutory provision. That time it was open for the division, for the council who appeared for
But
the.
if some statute
PWD.
has not been brought to the notice or not considered,
Then it will
is
notice.
it will be a
Can
kind
I
of an
say, my
embargo
lord?
for
If it is, if they have not brought notice before the court, before the division bench, I think they should bring it before division bench. With great
what is the
respect.
statutory provision? Which one? Forest regulation. What kind of notification?
Durga still.
Under
Durga still. You know, file कहाँ रहता है?
090.
Give me the enter file. Give me the enter file.
One second, exercise of powers. Schedule of rates. Schedule, yes. For what was ultimately said in Durga that whatever has been purchased from the open market, if they are able to show the memos that it has already been paid, then they are exempted. The procurement is done by paying the taxes, duties. There was another statute where
Forest Department মাজত
Assam. Very good. Where is the last part of Durga? Where is Durga? Oh, let me see. Maybe there. Durga we have. We have. Das. If you have Durga, you have Durga with you?
I'm sorry.
You
Durga,
have Durga, yes.
I've got Durga.
Paragraph 6.
Paragraph 6. Yes, I have seen that. I have marked. I have marked. Sir.
But
Your Lordship's argument.
I'm finding it slightly difficult now.
I'm sorry, my.
Finding it slightly difficult.
But that has been again coordinated by.
No, for taking up this matter.
No, I know, my lord. I have seen that. I have marked.
Let it go before somebody else.
No, I have seen that. But with great respect, but great
Let it
respect.
go before
But
somebody else.
I am telling my lord, with respect, what my particular view is your lordship. will
See,
not-
appearing is not a big issue. But having a view,
But RC and construction by coordinate means I decided.
understood. But this contention was made at that time.
If this contention would emerge, that's a
Now
different.
this contention has been upheld by division bench.
But
Let
this-
let it be for somebody else. Tomorrow there should not be any controversy. That opinion was already expressed. Maintainability of, we can now, since we are requesting, we would have ruled against you. We are not too much inclined. After the airport authority case, raising an issue like this, it's not a private dispute. Where actions of the state are in question on the touchstone of Article 14, you cannot bring in maintainability question. 1421, these are two broad issue which should be any embargo of maintainability would be there. Well, let it go for somebody else.
And all the problem will be solved if PWD insert that particular content that clause. All this problem will not remain. They will not do it, I know, my lord.
You take this book, this is not available here. আমার কিনিব লাগে এখন। Or read the Senior Council for the petitioner, also heard the Gogoi Learned Training Council Forest Department. The issue involved was also the issue before a division bench in which this court was one of the council. Full stop. So there is a subsequent, there is, so the learned counsel for the, senior counsel for the petitioner has submitted that there is another judgment of the Honorable Division Bench. This court is of the opinion that the fitness of things, the matter is required to be taken up by any other bench. Just according to for any other bench. Be clear. The decisions you have relied are in the file itself. You may retain it and place it before the court whenever it's, otherwise it will be in the file. Sorry for taking some of your time. No, that we are aware that this court was there, but the submission which was made, because the same thing we are trying to again. Justice not only has to be done, but seem to be done. Now, the other point is important, that 2020 judgment. 2020 judgment. 22 judgment or 20. The name is a very unique name. What was the name? No. Name was unique. What if you know this? No. Naam tu. Dragon. I think he was Dragon. He has become Draginder. Just right the direction. 2022. 378. CBI. Dragendra. Never heard such a name, Dragendra. Dragon crossing Jadan. Which was the Which was the para? By Madam Banerjee. 12, 15, yes. No, it has laid a broader proposition. Any issue which is raised but not expressly dealt with is considered to be dealt and rejected.
That's why. But my lord, I have found some judgments. So far, let us say in division bench in court number, division bench, maintainability point, that has not been argued, not decided, but it has been raised. Then it will open, subsequently also it will be open to argue this matter. Maintainability has to be decided. Now, in the judgment, something else has been said. That is, the merit of the case has been decided. It has ended in logical conclusion. Whether for the same issue, parties are also same, substantially involved, whether you can raise the maintainability point later on. Because subject matter being the same, here also the subject matter is same, my lord, regarding deduction of forest royalty. Council may be different.
Council
Doesn't make any
It
difference.
is the party is not the council.
Party is not the council. Briefly.
Yes.
Please, Your Lord. Mayor Council.
There is an I also,
Yes, we don't like it for
vacating state.
the next party.
I think we'll have that first or what?
But practically, my lord, that carried.
No, as you say, yes, Mr. Board.
Lordship, pleadings are completed in this matter, therefore it can be taken up for final consideration, but
We're taking up for final consideration.
yes, but senior counsel is on legs in court number.
Mr. Goswami is there.
No, senior counsel Ken Chaudhary.
Ken Chaudhary.
Lordship, I can just show the text of the matter at page 39, just the days. Or Lordship may take after some time.
After some time, 3:30. The issue is serious with,
Yes.
not like to go on a piecemeal thing. We'll give you full opportunity, but urgency factor is also there. That is why,
Construction of impench.
Yes, sir.
what to do?
I understand the difficulty, Lord, my lord's docket is full. My lord,
No, docket is not the problem.
but my lord, certainly, because my lord, at least I would also take half an hour as a, for the respondent. So if I take half an hour, if they take 15 minutes or even 20 minutes, then the 50 minutes go, and then maybe some counter reply, I don't know. That way, certainly, my lord, we hardly have much time today. I understand that. But then, that case, would it be?
There are
To my
two
lord,
matters,
will be-
Hmm?
2 matters, 30, 40.
Your brothers in arms.
Yes, they are brothers in
Different
arms.
parties, my lord.
Actually, my lord, what happened is 30 kilometers.
They are cousins in arms. Cousins in arms.
Cousins in arms, comrade in arms, and also brothers in law, practically. In a sense, I mean, not, actually,
Deep-
there is a
deep-
30,
DP and BP.
it's a 30-kilometer stretch, my lord, 25-kilometer embankment construction is.
I think you should come with reinforcement. Huh? Brothers in arms, you need reinforcement.
Actually, my lord, the respondent in this very particular case, the private respondent in this case is also the private respondent in the other case.
Who is the private
It's the-
respondent?
fact, respondent number 6 in this case is the respondent number 7 in the
Same.
other item.
Who's there?
Other
Who's
issue.
appearing? Who is appearing?
My lord, so far as the private respondent is concerned, since NSP has come before the honorable court, the private respondent is the beneficiary of the
No,
decision. of
have
NSPC.
they appeared?
They have not appeared, they have not filed any application also, since NSP is fighting it out. They have chosen to take a back seat. But the fact is, my lord, the issue is decided. So far as the decision of.
They have been
NSPC,
served. They have been served otherwise.
We don't know, my lord, NSPC has come. They are
Served or
not
not?
interested.
Private respondent served or not?
Notice has been issued, my lord.
Served or not?
It has come for admission, therefore it is, I think it is served.
That's okay.
Lordship, the basic question is,
Brothers in arms led by a formidable senior. Mr. Tiwari has to bring reinforcement now.
I'm ready with the reinforcement. But
My
the
lord,
issue is the time factor.
Yes. No, my lord, it's a matter is on a very short compass, my lord. What has happened, my lord,
No, Mr. Chaudhary,
Yes.
will you be able to complete the matter today?
may not, to be honest. As there are two matters. We can have it on, not on immediately on first 2 days, any day thereafter, my.
My lord, in fact, my lord, could it be that to
No,
No, other than first 2 days, I'm there.
this code availability towards the last part, we're not very certain, so we don't want to keep it part-time.
Okay.
Last week, code may not be there.
Could it that case may not of this Tuesday?
But if we can fix whether this code is there or not, we not know.
On a working day. Okay, no problem.
Okay, at least we try.
25th of
26th is
April,
a
huh?
Wednesday,
25th April is Tuesday.
25th.
Yes.
Yes, yes.
And my lord, in the admission, my lord, it may be slightly, if my lord suggests.
No,
No, this code's availability is not very certain on 24th. But Ben should be there.
Manish Chaudhary has a difficulty in this, can't take up. Practically, we have only.
Kollam.
No,
one
no,
on bench.
bench 4 is presently Justice Jyotan Kumar is there.
Or on my lord,
No, let it be on 25th.
second,
Try on 25th or
Okay.
second or third.
25th.
Okay,
I have no issue.
paucity of time did not permit the matter to be taken up. Full stop. As agreed to by the parties. List for admission,
Hearing.
admission hearing on
25.
25/4/2020.
Would it slightly high?
Yeah, it will come chronologically. If this
Pilot
code
team.
is there, you'll have the liberty to
My lord,
mention,
the
we'll upgrade it.
interim order will have to be extended.
Interim order passed today to continue to the next. If it comes before this code, we'll take it up at 2 o'clock or
My lord,
sometime we'll give it to.
Very
Otherwise, just in brief, what is the issue?
My lord, issue is, my lord, certain works for my lord, we call it,
Embankment, that's why I want to
Embankment.
know what is the ground of challenge?
the ground of challenge is first, we were made responsive. And subsequently, we were made non-responsive
Not in the first case.
in the second case.
In the second case.
Ah. And in the first case, my lord,
They are responsive, they remain responsive.
Ah.
But the private respondent will not become.
he has been made responsive. That too, my lord, by tinkering with various clauses of the NIT. For
This is
example,
only
my lord,
for-
after the last day update of submission of bid.
Hmm.
My lord, there cannot be any change in the, I mean, substance of the bid.
Hmm.
That is what we will argue, my lord. There's a specific clause which says any clarification or any change. in
Cannot change the
bid-
substance.
That is the only case.
That is the
And
law.
we have to argue that that very particular clause is not. And we are supported by the other clauses of the NIT.
And what about the first case? That how were you held to be unresponsive subsequently?
In the first case, my lord, they are responsive, they remain responsive.
No, 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 in the other one.
Second case, initially I was responsive
How were you made unresponsive? Why?
because private respondent has been made responsive.
No, that is okay. Then you'll fight it
No,
out. in the-
initially he was not responsive.
If you have to fight it out in the financial aspect, that's a different, but how are you made unresponsive?
Same argument, my lord. They, whatever they have done, they could not have done after the last date of submission of the tender clauses are very clear, my lord. There is one
No,
particular
that
clause.
I've understood for one case. That private respondent was not responsive that has been made responsive. But in the other case, you have said that you are responsive, then you have made unresponsive.
No, my
Why?
lord, what had happened, as far as the private respondent is concerned, he didn't submit a particular document.
Understood then.
Now that document, my lord, he submitted after the
Subsequent.
last date of
He
submission.
he was made
I'm
responsive.
taking note of that, no, the moment he is made responsive, my lord, I am inviting some more trouble. Why should I permit that?
That's one case.
Yes,
No, you said that in the other case, your bid has been made unresponsive.
and now that has been made unresponsive.
Why?
No, they say, my lord, there were certain, infirmities in evaluation
In your,
in my.
that is what is the infirmity?
There's no, according to us, there is no infirmity. According to them, there is infirmity.
This is for two works.
Two works, two different works. My lord, for addressing the downstream impact of the, my lord, flow of water, these measures are there. These are not measures to be taken lightly as far as people of Assam is concerned, my lord. We have seen how a whole
This is-
district, my lord, has been washed away every time there is a flood. But this is what happens, because they release the water. Because, my lord, the money which is required for constructing a dam or a power project, more money is required for, my lord, addressing the
Downstream impact.
Yes, impact, which is not being taken. That is why all this happens. Therefore, these are the measures for those works. One has to be very careful, my lord. It's not a question of choosing a
Only
contractor. or what.
only two bidders were there.
No, others are also there. Total nine.
There were many. I am going to demonstrate that we took the right decision. As to why the decision was right, I will demonstrate. There is no infirmity whatsoever so far as the decision making process is concerned, and also the decision per se is sound. To demonstrate.
Otherwise, also soundness we may not go into. We'll only go to the lawfulness.
Lawfulness also not. the scope
CCL.
is- the scope is limited.
We're trying to borrow some terms.
Because there has to be perversity, there has to be
In fact,
arbitrariness.
nowadays,
All
my lord,
There has to be prima facie material that the decision was the intention to favor somebody.
You're correct.
Otherwise, the law scope is very.
nowadays, while settling the petition, my lord, we use that phrase. The idea is not to test the soundness or the lawfulness. Justice Madan Lakhot.
And now, my lord, the Supreme Court also has gone to the extent of saying decision making process and the decision both should not be interfered with in the infrastructure project ordinarily, and parties may be delegated.
That
to
is
see
after
them.
the amendment of the specific relief act.
That is my yes.
And
People
the-
forget that, my lord.
And the projects.
Nobody takes note of section
But
41 of this specific
Bholenath has
act.
said something else. Jai Bholenath,
Jai Bholenath, same bench.
same bench.
But my lord, there are two judgments that affect the lord. In fact, I will.
No,
show
that
you.
is
But
specifically on the
many parties did not
specific
go to
relief
that.
act. That amendment, double A,
That is especially for infrastructure.
infrastructure
projects.
projects.
But not in any case, I'm going to demonstrate as to not only the decision-making process, but the decision both were absolutely sound. And there is no infirmity whatsoever.
Okay, it'd be an interesting argument. We'd like to hear it.
Hopefully, my lord.
Hopefully
my
we'll be
lord,
there.
I should be available on 20.
Hopefully.
We look forward to it.
Okay.
On
Yes.
25th.
Vishnu? Yes, next. Hmm. 30,
Yeah, please, Lord.
yes,
In this case, my lord, the.
yes,
petitioner
yes,
has
any,
taken
any
a
response?
similar
Take the
alternate-
instructions, ex gratia, isn't
Yes,
it?
my lord, yes.
Take the instruction. Sri N. Goswami, London State Council, prays for, and is granted time of 3 weeks to update the instructions. Mr. Chaudhary, which matter is yours?
Okay.
You're sitting for a long time. Which matter?
Item
30?
35.
The next matter? Okay, okay, very good.
So in this case, my lord,
Oh, that neighbor,
yes, my lord. The
Mr. Mannan,
GMD has fixed a hearing tomorrow, my lord,
tomorrow.
So
Okay, okay, okay. Yes, Mr. Naik, you take the decision judiciously so that matter ends.
submission was made, but we did not get any notice, my lord. That is why now I have been informed that a notice has been received regarding hearing that has been
Tomorrow,
fixed tomorrow, my
tomorrow.
lord.
The learned counsel for the parties jointly submit that a hearing is fixed tomorrow, data bracket up, by the GMC, GMDA, full stop. In view of the above, let this case be listed after 2 weeks. So that
Date may be fixed, my lord.
after two, so that the outcome of the hearing fixed tomorrow may be apprised to this court. List on. Tell us. Please, 11th, we'll have it on 28th,
20,
28, 28,
282, already.
Friday. Arrested.
উপর ফাইল তো দিয়া আছে
Oh, those essential matters.
Item number.
My lord, item number, my learned friend is right, my lord, 83, 85, and actually I appear in 86. Now, my lord, there is an order issued by the authority whereby, my lord, virtually they have accepted what we are saying. But only problem is, my lord, I can't say it is infrastructure because I'm asked my junior, my lord, there's no instruction from the client. So items number, he's right, my lord, item.
No, we'll record the submission and say that there is no life cause of action.
Yes, yes. In fact, there is a letter, I think in view of this, perhaps, my lord. I can't decide.
Regarding item number 87, my lord, I have got the
Second, I
instruction that, my lord,
You don't want to press.
no, my lord. One part has been, they have released the money in respect of the uniform for the class, my lord, 1 to 8. And then not in respect of class 9 and 10, my lord. Both the class, they have not released yet. But one part they have released, my lord, which are the matter of the tender.
One second.
My lord, I can say only in respect of item number 86, na? It's a fact, my lord, virtually our contention has been accepted. They have released the money also. It will say with the number of students.
No, this is not, what is this got to do with your grounds of challenge?
And it's a uniform meter.
No, this is only the fund sanction for procurement of school.
They are free.
My lord, earlier SMC, as per the NIT, my lord, SMC was not in the loop. Big, I mean.
Central.
Central.
Now it will be done by the SMC. Okay. Oh, to that
I
extent.
think this will clarify the position.
Is it 9-3?
The original order, my lord.
9-3, no.
No, my lord, this is.
Before that, all the.
8 तारीख to 9. Code.
After the signature, perhaps.
3-3, my lord.
I think that would be relevant.
3-3.
86, you're right.
Only thing is there is no communication from the
Okay.
client. That's why.
Part 3, K. N. Chaudhary, Senior Counsel, assisted by
And
MSN Mohanto for the petitioners. Also heard Sri S. Bora, Standing Counsel, SSA, Samagra Siksha, Assam. Full stop. This court has been informed that a decision has been taken by the authorities for procurement of the uniforms of the students for secondary and elementary education, students of students at the level of secondary and elementary through the SMC of their respective schools. In this connection, a communication issued by the mission director, SSA, to deputy commissioners of all districts and the principal secretary of the Autonomous Council dated 2003, so 2023 has been placed on record. Sri Bora, Sri Learned Standing Council has also placed a copy of the written instructions dated 9/3/2023 regarding the same court of para. In view of the above, this court is of the opinion that the grievance of the petitioner has been petitioners has been substantially redressed, full stop, and redressed and there is no live cause of action to be adjudicated, full stop, para. In view of the above, writ petition stands closed. Copies of the orders dated, communications dated copies Copy of the communication dated 3/3/2023 is made part of the records. This will not. This do you have an extra copy, Mr. Chaudhary?
No, my lord.
This one?
What we'll do, my lord, I'll make a Xerox copy and hand over.
No, we'll make it, don't worry.
Okay.
Matter copy. 83,
And 86.
86 we have passed orders, and 83 instead, Mr. Goswami, you're there?
Attended by 82 and 84. Lord.
82.
No, 82, 84, 82 are funny charge.
No, this will be in which?
My lord, 83,
83, what
85,
is- what is
86,
your name?
87. Harsha, my lord.
You're appearing here in this matter?
On behalf of SK Goswami. Lord.
No, we'll record your name.
Sure.
R. Sharma likhi diba, prothomte. All R. Sharma. In 83, same order, and
85, 86, 87.
83, 85, 86, and 87 we have already, 87 also, no.
Yes.
87 close. Not for elementary,
Elementary fund has been provided, my lord.
not for secondary. Then I will not close it, not look, not
87
be
to
proper. All the 86 up to Mahila, you put in 83 and 84 also, 85 also. 83, 83, Mr. R. Sharma, and in 85,
Yeah, SK Goswami.
85 who's there?
Oh, dear.
R.K. Saha.
Oh, dear. I think my learned friend is saying he's led by Mr. SK Goswami.
Yes.
He says 83 should not be closed.
We
That
have
may
no
be-
instruction, Lordship.
No, we are not closing on instructions, we are closing on the same. Is there a instruction?
Oh, hi.
Is it elementary and secondary?
Yes.
Uniform, it's closed, it's closed. Mr. Goswami, otherwise he's in
No,
the court or not? He's not in the court. Sure, Mary. Okay, others?
That may be segregated. Huh? Lordship may fix another date, my lord.
And 87 also.
Hmm.
82, 84, 87, Rekhiba. List these cases immediately after the Bihu vacation.
Interim order may be continued.
Sarah, interim order passed earlier, if any, to be continued till the next day of list.
Deeply.
Apply, Lord.
Yes, please, your lordship. As per Lozama Code Order dated 1/2/23, service is complete, lordship. It is matter for admission here.
15 matter, why is it pending?
Item 38.
2015 matter. After 19, it has not come.
Newly engaged, your lord.
No, after 19, the matter has not come.
No, lordship. Come in Lozama Code.
What is your name?
P. Sarma.
Off. Third, MS P. Sharma. Learned counsel for the petitioner who has referred to the order dated 1/2/2023 of the learned laws court, as per which the service is complete. Full stop, para. List this case for admission on 21st of April.
My lord, as per Lojama, dated 6/3/20, my lord, notice is been served. And also they have received as per flag X, my lord.
SBI, they have got a panel of lawyers.
Nobody is happy.
They do not have a standing counsel, but they certainly have a panel. Mr. H. Buragohai, then Mr. M. Sharma. See, this letter, though it is not in the correct order or procedure, it has been written directly to the assistant registrar. But something very important has been revealed, that the entire loan has been sold to the asset reconstruction company. And your challenge as such would be against ERCIL, whom you have to make party. I think better procedure is to file an application, make this a party,
My lord. actually
because
this
SBI is
letter-
not going to
Yes,
contest this matter.
okay.
They are not interested.
My lord, I will have to receive the letter, my lord. This letter is not furnished to me.
This letter is not written to you. This letter is addressed to the registrar.
Yes, sir.
It is not the procedure. They have to appear and they have to
My lord, by
say through a
affidavit.
council, but
Yes.
nonetheless, this is brought to our notice. So it allow you,
To implement.
will, and we'll record this in this order, okay? This is item number. You have also entered appearance lately, earlier you were not there.
Yes, no, not.
Part 3, DCC Fukar Learned Counsel for the petitioner, who submits that who by referring to the order dated 6/3/2020 passed by the learned Lozima Court has submitted that service upon the respondent numbers 1 and 2 has been held to be complete. Full stop. This court, however, has also seen the note, the office note dated 6/3/2020, which refers to a letter received from the Assistant General Manager, State Bank of India. Though the procedure adopted in issuing a communication directly to the registry is not the correct one, comma, a perusal of the said communication dated 19/9/2019 would reveal that though that in respect of the housing loan offered to the petitioner, comma, the loan account was declared NPA on 1/12/2009 and thereafter the account was sold to the Asset Reconstruction Company within bracket India Limited within bracket ARCIL on 23/6/2014. Full stop. It has further been, it further reveals from the letter that all the documents and papers of the loan file has been handed over to the ARCIL whose address has also been given, which reads as follows. Address to the wrong flag or paragraph 2. Wrong margins. ARCL তলত এনেকে address লেখা আৰু Guwahati address only. Oh, it has learned that the office of the ARCIL has been shifted to Kolkata. What will you do? I said, it has further been stated that the office of ARCIL has been shifted to Kolkata. Full stop. Error. Under those circumstances, comma, this court is of the opinion that unless there is implement of the ARCIL, whose presence would be necessary for a complete adjudication, comma, this case, it would not be prudent to proceed with this case. Full stop. Accordingly, comma, Sri Fukan, the learned, no. Further, this court has noticed that all the aforesaid transaction had taken place prior to filing of this case, and therefore, the same should have been incorporated in the writ petition, which unfortunately has not been done. Full stop. Be that as it may, comma, Sri Fukan, the learned counsel for the petitioner, prays for some time to take adequate steps, to take instructions regarding the steps to be taken to implead the new incumbent as party respondent. Full stop. Sarah, please, after 2 weeks, 2 weeks, you get a copy of this order. It will be easy for you.
Please, your lordship. In this matter, there are actually a PIL was also filed on the same subject.
Yeah,
And,
okay.
This what has happened here. We have challenged an order, notice in fact, of our shifting our hide and skin go downs from a particular place in Nagaon to beyond the municipal limit. An order was passed. And the order was on the basis of a particular letters complaint issued by a particular committee. That committee filed a PIL. That PIL was ultimately dismissed. On the basis of that, these orders were based, since it is based on those complaints, should go. That is basically my case.
You have the PIL order.
I have got a copy of it. I have actually, it's not a certified copy. I have taken out from the
Mr.
internet.
Goswami, what do you say?
And in fact, the Pollution Control Board have also filed their affidavit. They have indicated this order in their affidavit also. The,
Heard. This is item number,
40.
you are appearing for whom? Are you, where is the pollution control? They are a party.
Pollution Control Board has
Mr.
filed a.
Barua, he was here. As Barua.
To Deputy Commissioner, no.
Mr. Goswami, can you call Mr. Barua? We'll record his presence also. Huh? Left.
Actually, they have filed the affidavit. And in the affidavit, that they have indicated the order of the division.
Heard Sri Y.S. Mandan, Senate Council for the petitioner. Also heard Sri N. Goswami, Senate State Council for as per numbers. Why not one?
One also. One, three, and.
Which department? GDD, JD, Afukan. Don't write anything. I also heard Sri N. Goswami, Learned Government Council. At the outset, comma, the Mannan, the Learned Council for the petitioner, has submitted that the challenge made in this petition was also
No.
a subject matter.
No, not the challenge. In fact, they have issued these orders, the page 38, the series of this.
No,
order-
24/10/2016.
Yeah, this was not before the division.
No, it was subject matter was there.
Yeah, subject same because the complaint,
not-
everything was there.
We are not asking it.
Yes.
Listen to the order first.
Because
Uh,
this has to be set aside.
We know, the challenge made to, in this writ petition was also the subject matter of, PIL. Full stop. In this writ petition, comma, the challenge is against certain notices dated 24/10/2016 issued by the district administration, Nagaon,
To all the petitions.
to shift the hide HID, hide and skin godowns of the petitioners. Full stop. It is, this court is informed that the notices are the culmination of certain complaints raised against the business of the petitioner. And the same complainants had also approached this court by filing a PIL. Full stop. However, PIL as with a prayer for taking action. Full stop. However, comma, the division bench of this court by order dated 1/11/2017 had dismissed the PIL registered as PIL number 48 of 2016. Full stop. The Learned Council submits that when the Honorable Division Bench had dismissed the PIL pertaining to the same issue, comma, there cannot be any justification for continuing with the impugned order, impugned notices dated 24/10/2016. Full stop. Sri N. Goswami, Sri N. Goswami under State Council fairly submits that since the Honorable Division Bench had refused to entertain the PIL filed by the complainant, comma, there may not be any legal basis in issuing the impugned notices dated 24/10/2016.
In fact, they have filed the affidavit.
The
Para
records,
6.
the records reveal
That would
that
be-
the Pollution Control Board, which is a party respondent,
I get it.
has also filed an affidavit in opposition
It-
annexing
Photo the-
the aforesaid order dated 1/11/2017 passed by the Honorable Division Bench in the PIL. Full stop. Para. Considering the above, comma, this court is of the opinion that there is no basis that since the basis of issuing the impugned notices have been have not been have not been given any recognition by the Honorable Division Bench and the PIL 48 of 2016 being dismissed, comma, the impugned notices are not sustainable in law, and accordingly, the same are set aside. Petition accordingly stands allowed. What is the IA?
I think was for hearing of the matter, I think, early hearing. That
Oh, look at it. Okay. In view of the orders passed with the main petition, no separate orders
only
are
for
required to be passed
implementation.
in the IA, and the same stands closed.
That was for implement
Yes.
of response.
Next.
Much of it.
Your lordship, in this case, managing partner of the petitioner company had died, your lordship, in 2020. So we do not have any contact with them currently. So your lordship, kindly give us some time so that we can.
We'll close it, we'll give you a liberty. Okay? We'll close it due to lack of instruction, but we'll give you a liberty that if there is any instructions, you can come back, okay? Your DDECA,
R command.
your R common, your name is not there.
Yes, your lordship. I'm for DDECA, your lordship.
Hard Sri R common learned counsel appearing on instruction of Sri DDECA, learned counsel for the petitioner. The common, the learned counsel has submitted that it's a partnership form over
Yes, your lordship.
that as per instructions, common, one of the partners have passed away and there is no, as per information, as per information, comma, one of the partners of the petitioner has passed away and thereafter there is no further instructions. Full stop. There are considering the subject matter and also the fact that the petition is pending since the year 2017, comma. This court is of the opinion that and in view of the instructions mentioned, observed above, comma, petition is closed. However, it's a liberty to the petitioner to file for restoration if there is any existing cause of action. Sarawat Lihiba and Goswami for state government.
Oblige, your lordship.
May I please, your lordship?
Yes, yes, what is this? Oh. Yes, 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 madam. Let me know, how much time? 3 weeks? What is the matter?
We have served the copy, my lord. I have the
Whose signature is there?
Deedas.
Your signature?
It's on 26.
Madam, your signature? It's your signature. Okay. Cannot do this.
But copy was served, my lord, as per order.
To whom?
Someone did us, my
Who's did this, madam?
pending council STC on.
Your colleague? You have an extra copy?
Yes, my lord. I can give right now.
See, he's so generous. Next time you cannot deny.
My lord, in the it may be fixed for admission, my lord. In the meantime, pleadings may be exchanged.
What is the matter about?
My lord, regarding the allotment of a room, my lord,
Where?
in SC Rongia, my lord. Initially, it was allotted to the petitioner, my lord.
the proper money was paid, my lord.
You're
Subsequently-
you're protected by an interim order.
Yes, my lord. Interim order is there.
It is, this court has been informed. No, what is your name?
A Rashid.
Heard, huh? Heard Sri A. Rashid, learned counsel for the petitioner. Also heard MS MD Bora, learned standing counsel transport, who however submits that ASTC is the principal respondent. Madam, your name? Enat, MS Enat, however submits, MS Enat, learned counsel, however submits that her senior Sri J. Roy, senior counsel, appearing for the ASTC is not well. Full stop. He further submits that an extra copy of the petition may be furnished. Full stop. Sri Rashid has served an extra copy to MS Nath in the court itself. Sarah, list this case after 3 weeks. 3 weeks for admission. Interim order passed earlier. Why is it for orders today? Passed earlier to continue till the next date of listing. Just a minute, huh? What are these? What is it, Master? Yes, for admission, you come for admission. 3 weeks.
Oblige, your lordship.
Interim order to release it. Yes, next. Yes,
May I please, Your Honor?
yes, yes.
Honor, we may be allowed to take press steps on respondent number 3, 4, and 5. Yeah.
The office note, the order dated 6/1/2023, passed by the learned Lozima Court. Reveals that in spite of repeated directions, the petitioner has not taken steps for service of notice upon the respondent numbers 3, 4, and 5. Full stop. Sarah, your name?
S. Ahmed, on behalf of.
Sri S. Ahmed, learned counsel for the petitioner, however, submits that an opportunity may be granted to take steps upon the said respondent numbers 3, 4, and 5. Sarah, in the interest of justice, the petitioner is allowed to take steps. No, in the interest of justice, 2 days' time is granted to the petitioner to take steps on the respondent numbers 3, 4, and 5 by registered post with AD. List after 4 weeks, along with service report. Take steps by tomorrow.
Yes, I'll have.
Yes, Mr. Bakshi, what is this?
Respondent number 5 is the secretary of Dimuguri Gaon Panchayat, my lord. Perhaps PNRD is the department who will accept the steps, and AD not requirement, registered AD. And step level is ठीक है sir, inadvertent. I can give the.
5 is per secretary. Secretary, a government advocate can take.
Yes, PNRD.
PNRD, who is for PNRD?
Play.
Mr. Dr. Mr. Devnath. Not reflected.
My lord. Inadvertently, my lord, a private party along with the.
We'll do one thing. We'll have it listed on the reopening, directing list, reflecting of the name of one of the, that will be better. Order dated 19/2/2021 had required the petitioner to take steps, amongst others, on respondent number 5 by registered post with AD. Sri Bakshi, the learned counsel for the petitioner, however, submits that respondent number 5 is the secretary of a Gao Panchayat for whom the learned standing council, Panchayat and Rural Development Department can appear, full stop, para. However, since the name of the standing council, PNRD, has not been reflected in the cause list today, comma, registry to list this case on 21st of, not 21st, 21st of 21/4. By reflecting the name Kuluna. Your name? For who is respondent number 2? My name. It's okay, we'll record your name on the next day. Today we are not passing a name for it. You have made parties by name, why?
Lord,
Any Malafedi?
yes,
There is no environment.
whatever.
No pleadings. Why have you made party by name unnecessarily?
I'll file additional affidavit. I have to briefly-
Yes, next.
My lord, in this case, my lord, Lozime court had passed the order, my lord, regarding service on the respondent number 5, my lord. My lord, in fact, my lord, respondent 5 has withdrawn, my lord, his earnest money from the tender process, my lord.
Hmm.
And probably, my lord, that's why he is not representing, my lord, the court, my lord. And you see the, my lord,
Sri Hawk, the learned S. Hawk, learned counsel for the petitioner by referring to the order dated 12/9/2022 of the learned Lawazima Court has submitted that as per the said order, service upon the respondent number 5 is deemed to be complete. Full stop, para. The observation of the Lawazima Court is accepted. Full stop. The B. Gogoi learned counsel for the Public Works Department. Praised for and is granted 2 weeks time to obtain instructions. Especially with regard to the submissions made that the respondent number 5 has withdrawn
yes.
the earnest money deposit. Yes.
The I is for substitution, 2 and 3.
Substitution.
Yes,
Yes.
the father died. Para 2.
What is this matter about?
The petitioners are in occupation of a land since last long 78 years.
Part 3, D. Bora, learned counsel for the applicants who by means of this petition has paid for substitution of the petition numbers 2 and 3 by their legal heirs.
One of the legal,
Hmm?
by one of the legal,
By the legal heirs.
legal heirs.
Both of them have died.
Father died. Both of their father died. All are brothers.
Chandrakanta Burwa too. Chandrakanta has died, Ashut Burwa has died.
Yes, sir.
Because Viman and Borua, both are different.
Two died.
Yes, Viman and Vikas would be two applicants, isn't it?
Two applicants. You have enclosed legal documents, NOK also.
Who are the applicants here?
Applicants are their sons.
Where? In the cost title?
One and two.
Not like that.
On the date of legal, it is handwritten on the date of legal heir. Chandrakanta Borua, his legal heir. And next,
No, it's not like that. The applicant should come separately. Can you make the amendment? Here, they are not there even applicants. Only those two have to be applicants here.
the applicants are Vikas and Viman.
The writ petition, there are how many petitioners?
Total
There are not.
six petitioners
6 petitioners. Out of them, two have died.
who have died.
2 will be replaced by their legal heirs. These legal heirs have to be applicants in the IA. Separately. It is only on their instance we are entertaining this IA to get them substituted in place of their the persons who have died. Small bill. The applicants, a prayer has been made to substitute the petitioner numbers 2 and 3 who has passed away, who have passed away, who have expired, believe it. Whereas the petitioner number 2, Chandrakanta Borua, is to be substituted by his son or what?
Son.
Son, Sri Viman Borua, comma. The petition number 3, Ashut Borua, who has passed away, is to be substituted by his son Sri Vikas Borua. Full stop. Sri Bora, the learned counsel for the applicants, submits that the cause of action is a surviving one and the right to sue survives. Full stop. Also heard Sri and Goswami, Learned State Council, as well as MS G. Hazarika, Learned Training Council, Revenue Department, full stop para. After hearing, this court is of the opinion that the interest of justice would be served by allowing this petition, by allowing the substitution as sought for, full stop para. In view of the above, the IA stands allowed by allowed and the respondent numbers and the petition numbers 2 and 3, namely so and so, be substituted by their legal heirs within bracket sons 3 so and so.
Viman Borua.
নাম কেন পাই যাবো বড় মানে চন্দ্রকান্ত to be substituted by Viman Borua, Ashut Borua to be substituted by Vikas Borua. উপর লিখিছে এইমাত্র। I accordingly stands disposed of in the main WPCU, right? In view of the order passed today, that is as it is 11/4 in IA number 40 of 2023, registry to make necessary insertion, public correction in the cost title by substituting the names of the petition number 2 so and so by so and so, and petition number 3 so and so by so and so. Full stop. Let the petition be listed for admission immediately after the view vacation. Full stop. The interim order passed earlier to continue till the next date of listing.
Or may I pay for until further order? Interim order dated 29.
Now we have
2008.
to send extended till next date of listing. Yes, next.
Obliged.
With your lordship's indulgence, my lord, item 44, there is an interim order, my lord.
44 is interim order, okay,
Yes,
44
that
interim.
is-
44 interim order passed earlier to cut it.
if you-
Mr. Mitchell? Forum, did you go to? No, that will we have to mention before court number 4. Not here. All listing before court number 4. There is no procedure of attesting a matter to a bench unless the Honorable Chief Justice decides. You have to mention before the appropriate court. It may come here or it may come before court number 4. Make a mention tomorrow. Not here in court number 4. Press matters, if there is some urgency, some interim order needs to be extended. Any matter, otherwise it's hearing. Listen,